today, as you can probably tell by looking around. So be patient. We're going to get to your case. We've got reviews to do first. Those are for people that have already been to court and been ordered to do something. This is a hearing to review whether you're making progress toward getting your stuff done. So the bail's going to call your name. If you're here for review, come up to the table to your right when your name is called.
Jonathan Carter, Aaron Adkins, Alexandra Basil, Jeanette Boyd, William Gullett, Shane Hatfield, and Ashley Huff.
Jonathan Carter, case number 19-2435 is here. You've got your community service done. Only thing you've got left is your fines to pay.
Yes, sir.
Looks like you did make a payment here recently.
Yes, sir.
Okay, keep working on that. Getting up to dates for hearings. Okay, I'm going to set your next hearing for January the 13th.
Okay.
Once you've paid this off, you can quit coming to the hearings, January 13th, 9 o'clock.
Yes, sir. Thank you.
You're welcome. Aaron Atkins is here. Sir Atkins, how are you?
Glad to be alive.
Me too. All right, can you make any payment on your fines today?
I ain't got no money.
Okay, are you staying clean and sober?
Yeah.
Let's say I want you to go do a urine screen. Go do a urine screen and come back. Alexandra Basil. It's not here. The bench warrant for failure to appear. Jeanette Boyd. 20-2482. You haven't done hardly anything on your case.
No, I just got out of minute reads. I did make a payment yesterday on my fine online, but I'm having to do community service through common police court also, so I've been trying to. But
Well, part of this is, restitution to another person.
yeah, that's the one I paid on.
$500.
That's the one I paid on yesterday.
Yeah, well, it's going to, at this rate, they're going to be waiting a long time to get their restitution paid, so you got to pick it up.
Okay.
I mean, I don't want to put you in jail, and putting you in jail doesn't help get the restitution paid, but you got to start taking this more seriously and get stuff done. There's no reason you can't get your community service done either, right?
Right.
I want a commitment from you this next week. I will need 1 day at least of community service next week. What
Okay.
day can you do it?
Saturday or Sunday?
No, it's got to be Monday through Saturday.
What time is it?
7:30.
7:30 here?
Yes.
Tuesday.
Tuesday?
Yeah.
Okay. Mr. Cooper, Jeanette Boyd is going to be out for community service on the 13th of December.
Okay.
Okay, your next hearing will be January 13th.
January 13th?
Yes, ma'am. 9 o'clock.
Your Honor, she's also compliant with services.
All right, thank you. That was Megan from Mended Reads.
And 7:30? 7:30.
Your review hearing's 9 a.m.
Yeah.
Community service is
Yeah.
7:30. Okay, William Gullett.
Yeah, very sure.
Yes, 0972. Is that Riverside? Okay, you've got your GED.
Yeah.
And a good report, negative screen, so that's good work. Is he available to do any community service now? What?
He
Yeah, I
be
should
able
go
to,
to like on my days off.
Oh, you are working still?
Yeah.
Okay, well, you need to get some of that done. You've done,
Should be able to come in on Tuesday.
okay. All right, get out and get that done. I'll set January 13th as your next hearing. 9 a.m. Ashley Hoff is here. It's case number.
Thank you.
You're welcome. 2758, 2724, 2718. Do you have a report?
No, I do not, but she is compliant with services.
All right, very
Yep.
good. Okay, that's the main thing for you, to stay compliant. I'll set your next hearing for January 20th. January 20th. 9 a.m. I'm gonna have to read this. It wouldn't go to. Okay, Shane Hatfield was called for. Shane Hatfield has not appeared. There'll be a bench warrant issued for failure to appear.
Emily McCoy, Brian Montroso, Gregory Hickson, Hannah Lahan, Corey Milliken, Christopher Reed, Nathan Rourke.
Change up the percent. All right, had a little computer issue, got resolved. Brian Montroso. Brian, can you make a payment on your fines today?
Yes, sir.
How much?
10.
See the clerk and do it. I'm not even, you got so many cases, I'm not even gonna put the numbers in. I set your next hearing for January 9th.
Thank you.
You're welcome. See the clerk. Emily McCoy. Okay, Emily McCoy was called for, has not appeared. Gregory Hickson. Gregory Hickson was here. Gregory Hickson,
Gregory Hickson.
he was here earlier. Made a payment on his fine, but he hasn't appeared and stayed. He still has community service and other things to do, so he gets a warrant for failure to appear for his hearing. Hannah Lahan, 2293. It's not a theft offense. You still have quite a bit of community service. You did one day since your last hearing. And can you make any payment on your fines today?
I'm waiting for a check to clear, and as soon as that clears, I'll make a payment.
Okay. Okay, get out and get the rest of your community service done. Yours is a newer case, so I'm going to give you more time before your next hearing. I actually set it in February, so it'll be February the 3rd will be your next hearing. If you get everything finished by then, you don't have to come back to the hearing.
Okay.
February 3rd at 9 a.m. Corey Milton,
Yes, sir.
220848.
May I approach, sir? I've got a certificate of completion.
Mail to get it. Okay, review of pathways now.
Yes, I'm an outpatient at the moment.
Okay. All right, we'll get copies of that for the file.
Yes, sir.
And I do, based on what your last urine screen was, I want you to go do a urine screen.
Okay.
Go get the urine screen done and come back.
Okay.
Nathan Rourke. Yes, sir. 212615. Okay, you finished your community service, you still have fines to pay, and you did make a payment, pretty substantial payment today, so. All right, I'll set you for February 3rd also. If you get it paid off by then, you don't have to come to the hearing. February 3rd, 9 a.m.
All right, thank you.
You're welcome. Christopher Reed,
Yes, sir.
22-257, 2282. Okay, it looks like you've done everything but your community service, and what about the 3-day program, the driver's intervention program?
No, I've already completed that as well.
Okay, I need a report on that. Oh, it is here. I
Okay.
just overlooked it. It is in the file. Okay, so the only thing you gotta do is your community service.
Yep. I brought in that medical, from my doctor.
Okay, well, here's the way that works. I gave you 20 days in jail, suspended it on the condition you do 5 days of community service. That's a pretty good deal.
Oh, yeah, absolutely.
You can't do the community service, you gotta do the jail.
Yeah.
Are you gonna do the community service?
No, yeah.
Okay, well, let's get it done. Give you some more time to get it done. February 3rd will be your next hearing. If you get it, the 5 days done in that time frame, you'll be completed. You don't have to come back. February 3rd.
All right, sir, appreciate you.
You're welcome. Okay, that finishes our reviews. The next hearings are what's called the arraignment hearings. So if you are here for a new charge, you need to be in the courtroom now. And what's going to happen is the bailiff's going to call names. And if you missed a hearing in the past, you're going to get called with the arraignments. Folks need to come in and have a seat. It's pretty crowded, but there are some places you can have a seat. There's some more on the other side. Okay, I'm going to explain your rights. I'm happy to go over it with every individual person. We'll try to do it in a group then, speed things up. It's all things you've probably heard before, but I need to let you know what your rights are and what you are waiving if you enter a guilty or no contest plea. You have a right to remain silent. You don't have to make any statements when you're called before the court. But if you do make statements, what you say can be used against you. If you get up and blurt out some admission that you did something, it's all on the record. The prosecutor can use it against you. You have a right to have an attorney. You have a right to have an attorney appointed if you can't afford one, and I have guidelines I have to go by to determine whether you're eligible. It depends on your family size and your income. You have a right to bail. You have a right to make the state prove any charge beyond a reasonable doubt. Those are your rights. That last one is the most important one, and the first one, the right to remain silent. You're waiving those rights if you either enter guilty or no contest. So if you don't understand what's happening, if you want to talk to a lawyer, if you want a trial, you should enter a not guilty plea rather than guilty. Only enter guilty if you fully understand what the consequences could be for entering that plea and are willing to accept it. Call the first case, please.
State of Ohio versus Wendy Short, case number CRB 22729.
Ma'am, you're Wendy A. Short.
Yes.
Ms. Short, you have a charge alleging that at Rome Township on November the 5th, you were the owner, keeper, or harborer of a dangerous or vicious dog, and that you failed to keep the dog confined, so you're charged with allowing a dog to run at large. That's a 4th degree misdemeanor. Maximum penalty is 30 days in jail, $250 fine. Do you understand the charge?
Yes, sir.
Do you understand your rights?
Yes, sir.
How do you wish to plead?
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
No, sir.
Are you going to get a lawyer?
Probably.
How much time do you need to do that?
I don't think very long.
Okay, well, let's look at the schedule. And I believe you work, and usually the cases are Mondays or Fridays unless there's a holiday involved, which there are some coming up.
Friday works best for me.
Fridays are best for you. How about January the 13th as your next hearing? Okay. At your request, I'm going to set it for January 13th for what's called a pretrial, and that'll be at 10 a.m. that day. I'm entering a not guilty plea for you. I'll let you sign a $500 signature bond. What that means is you're just promising to come to court as ordered. As long as you show up, you don't have to post any money. If you don't show up, then you have to pay the $500 as a penalty for not showing up. So sign that. Do you have any questions?
No, sir.
Okay, next hearing is January 13th, 10 a.m.
State of Ohio versus James Conley, case number TRC 222720, A, B, and C.
Sir, are you James Conley?
Yes, sir.
Mr. Conley, you have a complaint filed alleging that on November the 17th at 9:20 p.m., you were operating a vehicle while being under the influence of alcohol or drugs, and this is charged under the Chesapeake Village Ordinance. So it's a first-degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine, and 3-year license suspension. That's the maximum penalty. The minimum penalty is 3 days in a treatment program, $375 fine, and a 6-month license suspension. You're also charged with driving while you're under a suspended license, suspended operator's license. That's a first-degree misdemeanor. Maximum penalty, 6 months in jail, $1,000 fine. You're charged with driving outside your lane. That's a minor misdemeanor, no jail time. Maximum penalty, $150 fine. You're charged under the village ordinance with not having insurance. That's a first-degree misdemeanor. Maximum penalty, 6 months in jail, $1,000 fine. So those are the charges. Do you understand the charges, sir?
Yes, Your Honor.
Do you understand the rights you have that I explained at the beginning of court?
Yes, sir.
Any questions before you enter a plea?
No, sir.
How do you wish to plead to the charge?
Not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
You have a job?
Not right now.
You have no income right now?
No.
Mr. Stratton here? He's here, I'll point him. We're going to get the lawyer in the courtroom. He is here today. All right, this is Mr. Stratton. This is James Conley. It's a ODI charge from the village of Chesapeake that was transferred to this court. Not guilty plea is entered. We can sign a $1,000 signature bond. When would you like the pretrial, Mr. Stratton?
Your Honor, at this point, we're probably looking at the beginning of next year, I would suppose.
How about the 9th of January?
Yeah, that'll work.
January 9th will be the next hearing. As a pretrial, 10 a.m.
Thank you.
You're welcome.
Thanks, sir.
State of Ohio versus Mark Bays, case number TRD 222697. Mark Bays.
Okay, Mark Bays has been called for, has not appeared. He was summoned to appear in court today at 9 a.m. It's after 9 a.m. So there'll be a capias issued for his arrest to the State Highway Patrol, who was the citing agency. Make sure they see it out front.
State of Ohio versus Michael W. Smith, case number TRC 222716.
Sir, are you Michael Smith?
Yes, sir.
Mr. Smith, it's alleged that on December the 2nd at 10:26 p.m. in Fayette Township, you were driving a vehicle while you were under the influence of alcohol, that this would be your first offense, and that you took a breath test and tested 16 on the breath test. So there's the number I need to explain to you is what's called the per se level under Ohio law is 8. That's the per se level for a breath test. What that means is there can be a presumption that you're impaired if you take the test over 8. In order to have the presumption, the state has to show they gave the breath test in accordance with the rules for giving it. There are several things they have to do, like calibrating the machine and so forth. They have to show compliance with that to get a presumption. But they are alleging that your test score is above 8. If you're found guilty on that offense, the maximum penalty is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most the court can impose. There is a minimum, which means I can't go below a certain level, and that minimum penalty is 3 days in what's called the driver intervention program. It's just counseling, inpatient counseling for 3 days, $375 fine, and a 6-month license suspension. Do you understand what I've explained to you about the OVI?
Yes, sir.
And you've got 2 more charges. Driving without a driver's license, that's what's called an unclassified misdemeanor. There's no jail time, but you can receive up to 500 hours of community service and a $1,000 fine. That's the maximum that can be imposed on an unclassified misdemeanor. And then the last charge is failure to control your vehicle. That's a minor misdemeanor. No jail time, maximum penalty, $150 fine. So those are the three charges. Do you understand the three charges?
Yes, sir.
And you understand the rights you have as a defendant?
Yes, sir.
How do you wish to plead to these charges?
Not guilty.
You wish to be considered for a court-appointed lawyer?
Yes, sir.
Do you have a job?
No, sir.
You don't have any income at all?
No, sir.
Okay, I'll appoint Mr. Steyer to represent you. Need Mr. Steyer in the courtroom, please.
Get ready with me for my next.
Mr. Steyer, this is Michael Smith. It's a first offense OVI with a breath test of 16 is the main charge. I'm appointing you to represent him. I'm entering a not guilty plea. Generally looking after the first of the year for pretrial dates. Do you have dates that you're not available?
Give me 1 second here. No, right now it looks like I'm available pretty much throughout January at this point.
Okay. January 6th, it's the first Friday in January.
I'm available.
That'll be the pretrial, January 6th,
I gotta be here January 6th.
10 a.m. Mr. Smith can sign a $1,000 OR bond.
First I'll sign your name right here. Now, January 6th. At 10 o'clock. So, I'm gonna grab your file, come out there and talk to you. You just wait in the lobby for me. Thank you.
State of Law versus Quasi Esfero, case number CRA 22-552 A and B. Your Honor, this is the preliminary. This is Mr. Clark's request.
All right.
May I approach you?
Calling this out of order at Mr. Dwyer's request, there's going to be a waiver of the preliminary hearing.
That's correct, Judge. May I approach?
Yes.
I've gone over with Mr. Farrow this morning and his rights with respect to the preliminary hearing, and he's executed written waiver here today.
All right. Is that correct, Mr. Farrow? You understand that you are waiving a probable cause hearing today?
Yes, sir.
Okay. I'm going to accept your waiver, so that means your case is going to go to the grand jury. You need to make sure that Mr. Dwyer can get a hold of you, because one of the reasons you're doing this is to keep the bond you have, which is favorable. And if he can't get a hold of you, you could get rearrested and required to post a new bond. So make sure he can get a hold of you to come into court when he needs you.
All right.
Okay.
Thank you, Judge.
Your case is bound over to the grand jury.
All right, thank you, Judge.
State of Ohio versus Sierra Helms, case number TRD 22-2711.
Ma'am, are you Sierra Helms?
Yes, sir.
You have a charge alleging that on December the 5th at 3:18 a.m., you were driving a vehicle while your license was suspended. And the section they charge you with is a first-degree misdemeanor, which means the maximum you face is 6 months in jail and a $1,000 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead to this charge?
Guilty.
If you enter a guilty plea, you're admitting it's true and you're waiving your rights to have a trial and to have a lawyer. Do you understand that?
Yes.
Okay, I'll accept your guilty plea. I'm going to read, the officer read a very brief statement. I'll read that into the record, and if you want to make an explanation, you can. You don't have to. The officer says, US 52, defendant was stopped for operating a vehicle at 75 and 55. Driver was found to be suspended as verified by a computer. And it did show that you had proof of financial responsibility. Okay, do you have any explanation?
I was just on my way to work and I shouldn't have been driving.
I agree with that. Shouldn't have been driving, and you're on US 52 at 3 in the morning, all right? Do you know anything about US 52?
No.
Everybody here knows it's crawling with state troopers. And what are they looking for at 3 in the morning? Drunks. So, but they didn't have to look very hard for you. 75 is like, you just need a big red flag and wave it out. You know, things change. Let me educate you a little bit. At 2 o'clock in the afternoon, you might be able to do 65 on 52 and get by with it. At 3 o'clock in the morning, 65 is going to get you pulled over because they're looking for drunks. Here's the other thing. I mean, you look smarter than this. You know you don't have a driver's license, right?
Yes.
And you're driving 75
I was
on
late.
US 52.
I was late for work and I just obviously should not have been driving.
Okay. Well, those are all things you got to think about when you're driving or doing anything. You got to think about what you're doing. You obviously were not thinking about what you were doing. Can you get your license back? Do you have a Kentucky license?
Yes.
Can you get it back? What do you need to do? Let's put it this way. Do you know what you need to do to get your license?
Yes.
What?
I have to wait 3 more months.
Why? Why'd you get suspended? I've got a print out here, so I can probably look at it. And,
Driving with no registration.
well, that's pretty tough. Well, here's what I'll do. I'd rather you get your license back. I'll delay the sentencing and give you a chance to get your license back, and then I'll just give you a fine. If you don't want to do that, then I'm going to give you some community service and a fine. So what do you want to do?
Get my license back.
Okay, so you'll come back and show me you got your license back.
Yes.
And you got to be suspended another 3 months?
I believe so. I need to recheck it.
Okay. Let me see if I can tell. The Kentucky printouts are different than what I'm used to reading. I mean, I've seen them sometimes.
I can look on my phone. I have the date.
You've had some prior, you've gotten convicted before driving without a license, looks like a couple times. But you do have insurance. Do you have a job?
Yes.
So obviously you said you were late for work. Where do you work?
UPS.
That's a pretty good job. So we need to try to keep that. Okay, so I'm going to set your sentencing hearing out in April. So give you some time to try to get your license back and come back and show me that you did it, okay? I'm accepting your guilty plea, but I'll just delay the sentencing. So let's, in your work schedule, what's best, Mondays or Fridays, to come to court? Does it matter?
No, it doesn't matter.
Okay, I'm going to set it for April 3rd. That's the first Monday in April. April 3rd. Sentencing hearing. It'll be at 10 a.m. Start working on getting your license back. And I'm going to let you sign a signature bond of $1,000. So, yeah, what you're signing is like an IOU to the court. I owe $1,000, which I'll pay if I don't show up. As long as you show up, you don't have to pay it. If you can't get your license by April 3rd, don't blow off the hearing and don't show up, because then I have to issue a warrant for you. So this, I have no intention of putting you in jail, but you could wind up going to jail if you blow off the hearing and get a warrant issued. You understand that?
Yes.
So just come, if you need more time, things don't work out the way you thought, come back and explain it to me and ask for more time. Don't just blow off the hearing. Do you have any questions?
No.
April the 3rd, 10 o'clock, you need to be back right here.
Okay.
Hopefully with your license.
Thank you.
State of Ohio versus Brenda Griner, case number TRC 222709, A and B.
All right, Mr. Cummings, you're representing Ms. Griner.
I am, Your Honor. We'd waive reading, enter a not guilty plea, ask for an OR bond, and I believe I'm already here the first Friday in January, if that works for a pretrial.
All right, she can sign a $1,000 signature bond. I'll set the next hearing for January 6th of 23, pre-trial, 10 a.m. Not guilty plea is entered.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Gregory Hickson, case number TRC 212881, A and B. Your Honor, I'm told that he informed the staff last month that he was on blue jeans when he was called there for review.
All right.
He is there now.
All right, Mr. Hickson is appearing by teleconference. Did not realize that. Mr. Hickson, can you hear me?
Yeah, can you hear me?
Yes, I can. I'm going to start the recording.
Recording has started.
All right, I'll cancel. I had issued a warrant previously because I did a call for you and you didn't appear, so that's canceled. You did make a payment.
Yeah, I was trying to figure out my Wi-Fi. It's pretty crappy.
Okay, you did make a substantial payment on your funds. You still have to do community service, so get that done. I'll set your next hearing for review for January 20th. January 20th.
I was gonna ask.
Yes, sir.
I was gonna ask not to cut you off, but I was gonna see if we could set it out a little farther because the 6 months that you previously gave me was kind of perfect, and I actually have the money set up for my DUI class. I'm just trying to work out scheduling because I just recently got a new job because I was doing concrete. It was winter time, so I had to pick up a second job. So I'm trying to figure out scheduling and the perfect time within the next month or so to do the DUI class, and my plan was to come in with it all done next time.
Okay, well, you can do, when's the January class?
The 12th through the 15th.
12th through 15th? Okay, so this is after that. Are you able to do it then?
Well, I'm in Columbus.
Oh, you're going to do the one there. Okay, well, there's lots of them there.
I'm doing the class up here. I forgot what the program's called, but
It's
in Grove City.
There's it's called the driver intervention program. So there are several, I'm sure, in the Franklin.
Yeah, now I was making a specific name for it, but I know it's in Grove City that I have to go to. It's the Best Western Hotel.
Okay, now I'm going to keep it for January 20th. I mean, this is a 2021 case, so you've had a while. My policy is I give you more time at the beginning, and then after time has gone by, then your hearings start getting closer and closer together. So get it done by January 20th. You don't have to appear.
Now, I had a question about the community service too.
You can do that in your home area.
Yeah, now, what's the specifics on that? Because am I able to I'm basically asking what should I do for that? Because
you can
I don't think. Is it literally suitcases, like stuff like that? Or
absolutely. If it's a legitimate charity and they have something they will send on letterhead saying what your hours are. You need 30 hours. Red Cross, Salvation Army, a mission, city mission, something like that, we would accept. Not your Aunt Susie, you're cutting her grass, nothing like that, okay?
All right, well, what about for working? Because my uncle offered me to do patios for free while I'm working with him, and then he can write it off. And
no, absolutely not. It's got to be a legitimate charity, not your uncle. Okay, that's all.
All right, thank you.
You're welcome.
State of Ohio versus William Joel Myers, case number TRC 222712, A and B. William Myers.
Sir, you William J. Myers?
Yes, sir.
Mr. Mr. Myers, it's alleged that on December the 4th at 3:17 a.m. in Fayette Township, you were operating a vehicle while you were under the influence of either alcohol, drugs, or a combination of those things. It's alleged that you submitted to a urine screen. So what happens with those is they get packaged, sent to the lab in Columbus for testing, and it takes several weeks to get the results. So I don't have any results at this point as to what the state's going to allege is in your urine. It is alleged to be your first offense. So on a first offense, the maximum penalty you face is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most you can receive. The least you can receive, if you're found guilty, is 3 days in a treatment program, $375 fine, 6-month license suspension. You understand that?
Yes.
Charge and possible penalties. You're also charged with having a headlight or headlights out. You're charged with a headlight offense. That's a minor misdemeanor, no jail time, maximum penalty, $150 fine. Those are the 2 charges. Do you understand them?
Yes, sir.
Do you understand the rights you have as a defendant?
I do.
How do you wish to plead to these charges?
The headlight one, I am guilty, but the other one, not guilty.
Okay, I'm just going to enter a not guilty plea as to both. Do you wish to be considered for a court-appointed lawyer?
Yes, sir.
Are you working?
I work at McDonald's.
Are you paid by the hour?
Yes.
How much per hour?
It's 11 an hour.
And how many hours a week?
32.
Okay, you're eligible for court-appointed counsel. I'll appoint Mr. Roger Smith to represent you. He is here, so we'll get him in the courtroom and introduce you to him. This is Mr. Myers. He has a Toledo address. Is that correct, sir?
Yes, sir.
I'm going to allow him to sign a $1,000 OR bond, signature bond. Is there a preference as to a hearing date?
Judge, I'm here, the rest of the month is kind of messed up. I'm here the 9th of January, the 13th, 20th, or 27th of January.
All right, and Mr. Meyer, since you're out of town, is Mondays or Fridays better for your schedule? Doesn't matter.
We do a Monday.
The 9th, January the 9th. Be a pretrial January the 9th at 10 a.m.
Thank you, Judge.
You're welcome.
State of Ohio versus Megan L. Brammer, case number TRC 22, 27, 24, A and B.
Ma'am, are you Megan L. Brammer?
Yes.
Ms. Brammer, it's alleged that on December the 7th at 6:53 p.m. in Rome Township, you were driving a vehicle while you were under the influence of either alcohol, drugs, or a combination of those things. And it is alleged to be your first offense. The maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. Minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. You're also charged with driving left of center. That's a minor misdemeanor. Maximum penalty is $150 fine. You understand these charges?
Yes.
You understand your rights?
Yes.
How do you plead to these charges?
Guilty.
Guilty means you're admitting that it's true, and by doing that, you waive the right to have a lawyer and to have a trial on the charges. Do you understand that?
Yes.
Okay, I'm going to accept your plea. It looks like there was a crash here, because I have a traffic crash report. And so I'll have a statement from the officer included. And I'm going to read that into the record. And then I'm going to give If you want to say something or as an explanation or in mitigation, you can, you're not required to. This was a State Highway Patrol trooper who says, I was dispatched to a two-vehicle hit-skip crash on Township Road 1053. When I arrived at the scene, I observed a Subaru Forester with damage to its left side from another vehicle. I exited the patrol car, spoke with the driver. She informed me she noticed a smaller four-door vehicle coming at her. Did not appear it was getting over, so she got over as far as she could, but still was sideswiped. She said the other vehicle fled the scene. She was not injured. There was damage on the roadway, and there was a piece of a hubcap lying down the road. While I was cleaning up the debris, the fire department located the centerpiece of the hubcap. The piece had a Toyota stamp on it. Fire department advised that they would look for the other vehicle while I completed my on-scene investigation. A short time later, I was advised that the fire department had located the vehicle that left the scene. I completed my on-scene investigation and will have to go locate the other vehicle. When I arrived, I observed a black Toyota bearing license plate number, which you give, face down in a ditch. I examined the vehicle and observed it had damage down its left side from a side swipe and was also missing a front head hubcap off the wheel. The hubcap located on the scene matched the ones on the vehicle. Made contact with the driver, who was identified as Megan Brammer. I immediately detected a strong odor of alcohol coming from her person. Asked her what had happened. She said she was trying to make a U-turn and ended up in the ditch. Asked her how much she had to drink. She said she did not know, but admitted to drinking wine. Asked her if she remembers sideswiping another vehicle. She says she does not remember if she had struck anyone. I obtained a statement about the crash and performed field sobriety tests. And asked her to perform the field sobriety test. She refused to do the field sobriety test. I asked her if she would take a portable breath test, and she said she would. She then provided a .215 portable breath test result. Her husband requested Nicely's towing, tow the vehicle from the scene. I brought the defendant back to my patrol car. She was read and shown the BMV 2255 form and offered a breath test at the patrol post. She stated she would take the breath test. I could transport her to the Ironton patrol post where she was offered a breath test. The intoxilizer gave 3 error codes on 3 attempted breath tests. I was unable to obtain a breath sample from the defendant. It appeared that the machine malfunctioned. I cited the defendant with left of center operating a vehicle under the influence and advised of her time to appear in court. Okay, ma'am, do you have any statement you want to make?
No, sir.
I'd like to know something about, well, first thing that jumps off the page to me, it says there was no proof of insurance. Did you have insurance on your vehicle?
I did, but my card was damaged. I brought a copy of it if you want it.
Yes, I have to have that,
Okay.
and we need it for the other person. Have you turned this wreck into your insurance company?
No.
Okay, well, I'm going to order that you do that. You have to contact your insurance company and tell them you were in this wreck. They have to take care of the damages that you did to the other person's vehicle. Okay, she does appear to have an Ohio insurance card with State Farm that was in effect on the day question. So we make, is this my copy to keep, or do you want that
Yeah,
back?
you can have it.
Okay, I'm going to put it in your file. Yeah, you can change it to show proof that she did have proof of insurance. Is there anything you want to tell me about this, about what happened?
No.
Okay, are you working?
Yes,
What do you do?
I'm a teacher,
Where do you teach?
Lawrence County.
What school?
The daycare,
Okay.
the early childhood academy.
Okay, well, you're lucky in this sense. You took a portable breath test and tested pretty high, 21. That's just for the officers used to determine if there's probable cause to arrest you. If it doesn't meet the standards for evidence in court are higher, so the portable breath tests, although they're pretty accurate, they don't come into evidence in court. The intoxilizer would have, but it malfunctioned. So if that would have come into evidence, if there had been an intoxilizer of 21, I would have to give you jail time. It's required for any test score above 17, which is considered a high test. So I'm not going to give you jail time, but what I am going to require, especially since you're a teacher, I think this is really important. You have to go to the driver intervention program, a 3-day program, but I want you to have more than that. I want you to have an assessment for substance use issues, and do you have health insurance?
No.
Okay, so you're not teaching in a public school then, it's a
No.
private daycare. Do you have a medical card?
No.
You don't, okay. I wonder if you're eligible. Have you ever had a medical card?
No.
How do you pay for health services, for medical services? You just don't get it,
I
or you
just
pay
don't
it
get
out of your
any.
pocket?
I mean, I don't usually see a doctor. I don't have any like health conditions or anything.
Okay. Well, and you're married?
Yes.
Okay, I'm going to refer you to Bethesda, and they can try, you might be eligible for a medical card. They'll try to assist you with that, but I want you to have an assessment. And if they think you need treatment, it probably would be outpatient. It's not going to be inpatient treatment, but I mean, there's some warning signs here that there's a problem that we need to address. So you're a pretty young person and really high test score, so let's nip this in the bud and get some help for it. Okay? So Taylor is here from Bethesda that does treatment, substance use treatment, and she's going to talk to you about getting you assessed.
Okay.
And you have to do that. It's not optional, okay? It's mandatory.
Okay.
Okay, I'm going to give you a $600 fine, which is a little more than the average fine, but you were pretty drunk from what I see. So my standard is the higher you test, the higher I make the fine. So, and if you had tested, if that portable breath test had been the intoxilizer and come in, you would have got a $1,000 fine. So I'm still giving you a break because the machine malfunctions. You got lucky on that. So $600 fine, court costs. I'm going to suspend your license for 6 months, and that started the day of the incident. 20 days in jail, and I'm going to suspend all your jail days on the condition you do the stuff I tell you to do. 1, you got 5 days of community service to do, and we have a community service program here. You can do it on your days off. You don't have to take a day off from work, but it's got to be a Saturday or the other 5 days of the week. We don't work on Sundays or holidays. You'll have a review hearing when you come back. If you were here earlier, you saw people coming in for their review hearings. That's when it's kind of judgment day. Did you do what you were supposed to or not? If you don't show up, we had some people don't show up today, they're going to get warrants, and they'll act surprised sometime when they wind up wearing an orange jumpsuit. What did I do? Well, you didn't do what you were ordered to. That's why you're in jail. So I don't want you to go to jail over this, but you can make it jailable by just not doing what you're supposed to. You understand?
Yes.
Okay, and that's going to be July 10th. So you got a long time to work on this before you got to come back in and I review your file. July 10th of next year at 9 a.m. will be your review hearing. You're going to be on probation for 2 years. That's just to make sure you get stuff done when it's finished. When you finish everything, you won't have to report anymore. Your probation effectively will be over once you finish everything. You do have to go to the driver intervention program and an assessment with Bethesda and treatment as they see fit. If they make a recommendation, if you disagree with it, you're going to need to come back and convince me that they're wrong about what you need for treatment. And most likely it would be some sort of counseling sessions, I would think. Okay, I think that's everything on the OBI. Then on the, we need to add this. Restitution, if there's anything that your insurance company doesn't pay, then you have to pay it. That's why I'm ordering you to notify your insurance company. They should take care of everything. You've got liability coverage. That should take care of all the damage to the other person's vehicle without you having to pay anything. So turn it in. So I want that person taken care of. I want their damages taken care of. Okay, on the left of center, I'll impose a $20 fine. Okay, so you're going to meet with, Maddie puts on our 3-day, Maddie works for Spectrum. Spectrum puts on our 3-day program. So she's here from Spectrum. You're going to talk to her about the 3-day school. You're going to talk, you got 3 people to talk to. Taylor from Bethesda about the assessment for some individual counseling. And then you're going to see Mr. Cooper is outside about your probation. And after you talk to those 3 people, you're free to go. Do you have any questions of me, ma'am?
Can I have like in writing of what I have to do?
Yeah, you're going to get a copy. I know I've thrown a lot of information at you. That's what she's doing. She's typing it all up in what's called a judgment entry, and you'll get a copy of that today before you leave, what you're ordered to do. And if you lose it or have questions, you can call the court, or you can go online. We have a website. You can pull up your case, and you'll see on there what your requirements are.
Okay.
Okay. July 10th at 9 a.m. is your next hearing bet. It's going to be on your judgment entry.
Can she get a permit to drive?
You can have a permit to drive after 15 days. You have to have what's called a hard suspension for 15 days. After that, you can get a permit. I'll let her drive for work purposes, to come to community service, to go to treatment. Is there any other things that you think are absolutely necessary for you to drive for?
No.
What about, do you have children?
No.
Okay. All right, see the 3 people, Mr. Cooper, Maddie, and Taylor, before you leave.
Out here?
Yeah, they're out. They'll follow you out in the lobby.
Okay.
State of Ohio recalls Aaron Atkins.
All right, Mr. Atkins, good job. Good hearing screen, so that's what I want to see. Set your next hearing, January 20th of next year. January 20th.
Thank you, sir.
You are. Merry Christmas.
Thank you. You too.
State of Ohio recalls Corey Milliken. Case number TRC 22-848 A&B.
Okay, you got a good screen too. Very good.
Thank you.
You've come a ways.
I have.
When you first came here, you
I definitely
did
have.
not have good screens.
I also wanted to thank you for putting me in inpatient, because I can honestly say that I probably wouldn't be clean if you hadn't.
Okay, well, thank you, and thank you for taking advantage of this. Now you got to keep working at staying clean.
Right.
You understand?
Yes, sir.
And, I would just say this, because it absolutely is true. It's very dangerous out there right now.
Yes.
There's a lot of fentanyl floating around in our community. Anything that you get from somebody that you don't know the source, like even if they give you a pill that they tell you, oh, I got a headache, well, here's an Oxy, take it. It might not be Oxy.
Right.
It could be fentanyl, and people are dying.
I believe that.
I don't want to be a negative because you've gotten recovery, but one of the people that are the biggest risks for overdosing are people in recovery that relapse.
I completely understand that, sir.
So that's a warning too. If you feel like you need help, there's people that will help you. And if you feel like you're going to relapse, We've got lots of folks that will talk you through it or help you do whatever we need to do to get you through that.
Yes, Your Honor.
Okay, you still got stuff you gotta do for the court. You got some community service and fines to pay.
I was gonna ask about community service, the care center that's in Ashland. I was wanting to see if that was approved.
I want you to talk to Mr. Cooper standing out in the lobby, so he's in charge of community service. Why don't you talk to him about that?
All right.
And if he says it's okay, then I'll go with it.
All right, I'm able to pay on my fine next Monday.
Okay. Well, other than the warnings I gave you, I also want to congratulate you and say you've done, you look so much better now than when you first came in this court.
Thank you, Your Honor. I appreciate that.
You can just see it on your face and the way you present yourself. You've done really well, and I'm proud of how you've done. So keep it up.
Thank you. I appreciate it.
I'm going to set your next hearing for January the 20th.
Okay.
For review, 9 a.m. And congratulations on graduating the program too. So
yes, thank you.
Treatment, but I think you need to keep working at it.
Yes, I am. Thank you so much.
Okay.
State of Ohio versus Austin Pritchard, case number CRA 181233 A and B, CRB 181234 A and B, TRC 183525 A and B.
And sir, you're Austin Pritchard?
Yes, sir.
Okay, it looks like the last hearing that you missed was in June 24th? Or July, sometime in the summer, you missed a hearing, is that right?
Yeah.
Okay, do you have an explanation for that?
Just been really busy with probation in Ironton. And
for common pleas or Ironton Municipal?
It's felony probation.
Okay.
And recovery.
Are you in treatment?
Yeah.
Where?
Bethesda.
Okay.
I just started there.
Inpatient, outpatient?
Outpatient.
And it looks like you got picked up on the warrant from this court and had to post a bond now, right?
Yeah.
Okay, so what's going to happen now? You still owe some fines, and it looks like there must be restitution amounts too.
Yeah.
From the amount. What's going to happen now is that you maybe already realize this, you've got a bail bondsman that's going to be after you if you don't come to court.
Yeah.
And he's not going to, if I send a warrant down to the sheriff's office, well, if it's for murder, they might go actually look for a person. But for an OVI, it just lays there until there's police contact, and then they go to jail. But that's not going to happen to you. If I tell Mr. Sowards, Austin didn't show up in court today, he's going to get in his car right then and start looking for you, and he does not miss people. He will come find you and drag you to the jail because he doesn't want to pay the $1,500, and he never does because he always gets his people.
I'd imagine he don't.
So what I'm telling you that for, you got to come to court when you're ordered to.
I'll be here.
And get this stuff done that you're ordered to do. That's all I want you to do. You've got quite a bit in fines and costs. You did do your community service, so that's done. Fines, costs, and restitution, it looks like. So we got to take care of the person that paid that money to.
Mostly restitution, ain't it?
Yeah.
Yeah.
Okay, I said last summer, I think it was November. November 10th is when you missed a hearing.
Yeah.
Okay, so anyway, you missed a hearing before. So let's, I'm going to set it in January, and it's going to be a sentencing hearing now because you've got a bond up. So 10 o'clock on January the 13th will be your next hearing for sentencing. And make a big note that there is now a bond up. Any questions, sir?
Yes, sir.
Okay. Get your stuff done.
Thank you.
You're welcome.
State of Ohio versus Matthew Turner, case number CRB 22474 A and B.
Okay, you're Matthew Turner.
Yes, sir.
And you had a review on November the 18th, it's the last you didn't appear for, on case number 22474 and 183631. You admit or deny that?
I admit.
You have an explanation?
Yeah, I totally forgot.
Okay, that's not a very good explanation. What caused you to remember?
My wife.
Okay, well.
And Your Honor, he is also currently patient.
Okay, you cut out on me. I heard the first part about he's currently a patient.
Yeah, he's a patient here and he's currently compliant.
Okay, that was Brianna Dement from OVP appearing by teleconference. Okay, that's good. That's a good thing. You still got fines, community service, and so forth to do. So I want you to start working on that. I'll withdraw the warrant I'd issued for you. We'll give you another re-hearing. And
I paid them up.
Note you're at OVP, so that's outpatient, I'm assuming.
No.
You're inpatient?
Yes.
For 28 days?
30.
30? When's your out date?
I'm not for sure. I've been there a couple weeks.
Okay, well, let's come back. You should be out by January 20th. Your next hearing is going to be January 20th. One thing I want to hear again is that you finish your inpatient.
Yes, sir.
He completes on the 3rd of January.
Okay.
I also paid on my fine today as well.
All right, very good. January 20th, and this will be reviews at 9 a.m. Any questions, sir?
No, sir.
All right.
Thank you.
State of Ohio versus Adam Montgomery, case number CRB 10710. I think he's on the show.
I'm here, Your Honor. All right, Adam Montgomery is appearing by teleconference. Oh, I think this is the one you called into court this morning, right?
I actually called in 2 days ago, sir.
Okay. Where are you living now, Mr. Montgomery?
I live in Alabama now.
Okay, can you turn on your video?
Yes, sir. Just 1 second. Let me turn the light, you can see me better. Okay.
All right, Mr. Montgomery, you had a conviction in this court on a theft offense, and looks like you had ordered to do community service, pay fines. Looks like you attempted to pay your fine, or did pay what you thought the fine was. The only thing you have now is a bench board fee because you didn't do the community service according to what I have. Is that correct? Do you agree with that?
I thought I turned in the paperwork for the community service, but that was also 12 years ago, sir. And then 2 years later, I joined the Marine Corps and did 5 years active duty in the Marine Corps. So I'm honestly not sure if I did that.
Have you got proof of your military service?
Yes, I do, Your Honor.
Okay, if you want to fax that to the court, I'll accept that as proof of your community service.
Okay, thank you, Your Honor.
So what I'm going to do, the way I keep track of things, we have so many cases, if I just say, oh, well, do that, and you don't do it, I'll never catch it. So I'm going to set another hearing, and if you've done it by then the case will be completed. Of course, if you want to appear by teleconference, you can to make sure that happens. But I'm going to set it for January the 20th. Get that in here before then, and the case is completed. I'll make a note of that. So that's going to be at 9 a.m. on January the 20th. Make a note that your military service will satisfy your community service requirement.
And then how much of the fine do I still have? Do you know, Your Honor?
If you send that in, I'll cancel the warrant fee also. You just have a $50 warrant fee.
Okay. All right, I will make that.
Do you understand understand what you need to do?
Yes, I need to fax in proof of my military service, so like my DD-240. Okay.
You can fax it or email it out, you just need to get it here and deal with the clerk's office on getting it here.
Okay, I can email it in the next few minutes.
Okay.
What would be the email address that I need to send it to?
Well, I don't have, I'm gonna call the clerk's office and get it from them, I don't have it right with me.
Okay.
Okay.
Thank you very much, Your Honor.
You're welcome.
State of Ohio versus Joshua Clyber, case numbers CRC 20-1541 A, B, and C, and CRB 20-644.
All right, Joshua Clyber is here. You missed the hearing on November 28th. Is that correct?
Yes.
Do you have an explanation?
I was thinking it was on the 1st or the 2nd, like it had been running. Then my dad went in the hospital that week. Totally forgot about it, and here I am.
Okay, do you have a payment on your funds?
Yeah, I was going to pay it. She told me to bring it back.
How much are you paying?
50.
Okay, and you got community service yet?
Yeah, I got to bring that card, and then so I got some community service a couple days.
You got some that you've already done, or?
No, I got to bring my vaccine in. I'll knock off a few, and then a couple days left after that.
Okay, we'll get it done. You're not putting in pools now, so there's no reason.
No, it's slowing down, so I'll have time now. Yeah, we've got a few concrete jobs to do, but it's slowing down.
January 13th is going to be your next hearing at 9 a.m. For you get everything finished, you can quit coming to these hearings.
Yeah, how much is the fine? I'll ask him when I get out there.
I'm showing $760 is what you owe,
So
and 5 days of community service.
Pay that, kill the community service, it's done.
Yes, sir.
All right, I'll get that done.
State of Ohio versus Brandon M. Coe, case number CRB 22777.
Sir, are you Brandon Coe?
Yes.
Mr. Coe, you have, the bail's bringing it to you, a domestic violence charge that you're being served with now. It alleges that on December the 5th of this year, at Rome Township, by threat of force, you caused Ashley Coe to believe you would cause imminent physical harm to either her family, or another household member of hers. And it's alleged that Ashley is a member of your family or household. That's a 4th degree misdemeanor. It carries a maximum penalty of 30 days in jail, $250 fine. Do you understand the charge?
Yes.
Do you understand your rights?
Yes.
How do you plead to this charge?
Not guilty.
Do you wish a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
Yes, I do.
What do you do?
I work for Lowe's.
Are you paid by the hour?
Yes, I am.
How much per hour?
$12.50.
How many hours a week do you work?
I get 24 a week.
Okay, you're eligible for corporate counsel. Mr. Morford? I'm going to appoint Mr. Morford to represent you.
Okay.
He is here, I understand, so he should be in the courtroom here shortly. I'm entering a not guilty plea for you. And is there a protection order requested? Wait till Mr. Morford gets in. Mr. Morford, this is Brandon Coe. He has a M4 domestic violence complaint. State's requesting a protection order. Is there any reason you can't stay away from Ashley Coe while the case is pending?
All my stuff's in my house, my kids. I watch the kids when she works. I work midnights.
Is she here today?
She's not here today.
Does she work?
Yes.
What does she do?
She is actually a activity specialist at a nursing home.
Okay. Is she reachable?
Yes.
Judge, I want to bring something to your attention. I think I represent his wife in a divorce action.
Yes.
Oh, okay. Well, then you can't do this.
I was going to say I probably should stay away.
Okay. All right, I'll appoint someone else then. We're back to Mr. Stratton. Mr. Stratton. So there is a divorce action filed, but you're still living together?
Yes, we're working together till, yes.
we have a hearing, Judge, we have a hearing Monday on possession of the marital residence, designation of residential parent, and some other relief, temporary relief at the beginning of the divorce action.
Okay, so she is seeking that then?
Yes, sir.
Okay, well, I'm going to order that you stay away then, since this has come up. I'm ordering that you stay away from Ashley. Is there another place you can go to, sir?
I can go to my mom's. Now, could I go to the residence while she's gone, where it's under my name, my house? If she's gone and stays that somewhere else, so I can be with my kids.
Not unless she agrees to that. You want to try to contact her?
We can try to contact her, although I don't, she's supposedly at work right now. Maybe.
Yeah, she's at work right now.
She answer the cell phone, or if she's called?
She should, but I may not, just depends if she's busy.
Okay, well, we'll give it a shot. Otherwise, the standard is going to be you stay away from her. She's not here charged with anything. You are.
Yeah.
So, well, she agrees to it, you're going to have to stay away from her.
Okay.
So I'll let the prosecutor try to get in touch with her, see what they can find out. So you talk to Mr. Stratton, and then we'll recall this later in the docket to figure out the terms of bond.
All right, thank you.
Including protection order.
All right, thanks, Your Honor.
You're welcome.
Yeah.
And I don't know if you heard it, but Mr. Morford is apparently representing Mrs. Coe in a divorce action. So it might be a source of some information for you too.
All right, thank you, Your Honor.
State of Ohio versus Linda Thacker, case number CRB 22775 A and B.
Ma'am, are you Linda Thacker?
Yes, sir.
Thacker, you have aggravated menacing and, well, 2 counts of aggravated menacing charges. The A case, aggravated menacing 775A, alleges that on December 5th, in Fayette Township, you knowingly caused Rush Coleman to believe you would cause serious physical harm to either his person or to his property. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. The B case, 775B, alleges that December 5th, you knowingly caused Samuel Coleman to believe you would cause imminent physical harm to the person or property. So 2 counts of aggravated menacing, 2 different people are the alleged victims. Do you understand the charges against you?
Yes.
Do you understand your rights?
Yes.
How do you plead to these charges?
Not guilty.
You want a lawyer appointed to represent?
Yes, sir.
Do you have a job?
No, I'm on SSI.
All right, Mr. Morford, I'll appoint you on the Thacker's case. Not guilty plea is entered for Ms. Thacker. She can sign a $1,000 OR bond. Is there any kind of protection order requested?
Yes, Your Honor.
Ms. Thacker, is it any problem for you to stay away from the Colemans?
No, sir. There's no problem.
All right, I'm ordering that to happen. You're not to go around them, contact them, post anything about them on social media. We want to let the fire settle down, not stoke it. When would you like to come back for the next hearing, Mr. Morford?
Judge, I'm at your convenience. I don't think I have any trials until after the beginning of the year.
How about Friday, January 6th?
I'm here then.
January 6th will be the pretrial, 10 o'clock.
Call my office and make an appointment to get in and see me. Thank you, Your Honor.
You're welcome. Okay, that finishes the arraignments we have for in-person. There's going to be some more we'll do for folks that are in jail. We'll do them by teleconference later, so we're going to start the pre-trials now.
run the current title. State of Ohio versus Lewis Denicola, case number CRB 22699.
This is Mr. Kermeen's case set for pretrial.
Your Honor, my understanding from talking to the state, who has spoken with the alleged victim in this matter, and we provided them with where there was a CPO had on this matter that was ultimately dismissed. I believe Mr. Hill is prepared to dismiss this on payment of costs, and we're okay with that.
Is that correct, Mr. Hill?
Yes, Your Honor, we confirmed that there was a hearing regarding a protection order and these very same facts, and the protection order was not granted. And so we are agreeable to a dismissal of the charges right now. The facts, or the situation between the parties had to do with co-parenting a child, and I think that they've resolved some of their issues.
You can pay the cost today.
Yes, sir. Yes, Your Honor.
See the clerk be dismissed on payment of costs.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus Michael G. Robbins, case number TRC 221566, A and B.
Mr. Kermeen's case set for pretrial or sentencing?
I believe it's actually a sentencing, Your Honor. Maybe approach.
Yes.
What is this?
She hasn't sent me today. I'll check, make sure she hasn't. So, are you ready to do something today, or? Well, before I would do that, I'm going to file a report from the DA or something, because it hasn't been. There's been some issues, I think, I'd like to see something. And maybe longer, if we could. Yeah, we can get, for sure we can get a report from the DA. All right, Mr. Robbins is for sentencing. I would like to have a final report from the DA, so we're going to schedule this for January the 6th and hopefully have that report before I conclude the sentencing.
Yes, sir.
I will contact Ms. Rayburn myself, get a report.
Thank you, Your Honor.
You're welcome. January 6th.
State of Ohio versus David Kochner, case number TRC 221615, A and B.
Approach, Your Honor.
Yes. I'm sitting there having text to review it. There's so much stuff. Are they aware of this?
Well, here's the thing. They're not big something, which means he probably won't get it. Because he sits here and does this occur. He's not. So we have that one.
I'm going to have to be convinced of that. If you want to follow them, it's set for a measure hearing on the 30th. So, if you want to follow, once you file something, ask them to court to consider it a first offense, and then I'll take a look at what you got. Once you file that, and then let's, look at pre-trial again before the 30th, before we know. And I'm not going to be here that week, I won't be here the 19th. Still ask for it to be considered. You're on that.
I'm going to have you because he doesn't approve that. Please provide me. And then we get you.
How about the 27th? Then? That's the Monday before the Friday. Okay, this case is scheduled for motion hearings on December 30th, but we're going to pre-trial this again because I understand Ms. Finley's going to provide some information, maybe another motion to the court on the 27th.
Correct, Judge.
So it'll be on the docket as pre-trial / motion, December 27th, 10 o'clock. We'll keep the December 30th date also.
Okay. Thank you, Judge.
State of Ohio versus Bernard A. Kincaid, case number CRB 22661.
Mr. Haslam's case, and it's set for a pre-trial today.
Your Honor, the state and I were able to reach a resolution in this matter. I believe that Mr. Hill has the terms of the agreement.
I do, Your Honor, and I've been speaking with Mr. Nixon from the state of Ohio, who was the investigating agent and actually appeared at the last hearing. And I want to be sure that I state what our agreement was yesterday. This was agreed to by Agent Nixon as well. Plea of no contest with a stipulation of the facts, $100 fine, and court costs. And we're not requesting any probation or suspended jail time.
And everything that was, the state was alleging was owed has all been, that's been resolved.
That's the basis for that, yes, Your Honor.
Okay. I'll agree with that, so Mr. Haslam.
Your Honor, at this time, Mr. Kincaid will enter a no contest plea.
Stipulate the finding.
He'll stipulate to the fines, Your Honor.
Yeah, Mr. Kincaid, anything you wish to say?
No.
All right, I'll agree with what's been proposed to the court, $100 fine costs. Can you pay that today?
Yes, Your Honor.
All right, no probation. See the clerk.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Bryce Butcher, case numbers TRC 193992 and TRD 201619.
This is Mr. Smith's case. It's actually pre-trial and review, I believe.
I believe that's correct, Judge. It's reviewing an old TRC matter.
And I think he has a case in common pleas too, you know.
Yeah. Who's that? Who's that one? Yeah, I remember which judge. Oh, about.
He does, he has a case with Judge Ballard in common pleas.
Well, he hasn't done much on these cases.
What is it now? You said you haven't done much on these cases? Community services? Community service and fines, Judge, on these cases still owed?
Yes.
Yeah.
$60 was paid, that's it. He was also ordered to get substance use counseling, and that, I don't see that that's happened.
He had an issue with his insurance, he's telling me he was trying to go to OVP, you might address the judge about your treatment.
It's like where I was supposed, you told me to go there while I was titrating down at the place I'm at right now.
Your methadone?
Yeah, but I guess where like, I have to do the counseling and stuff there, they can't bill both. Like one can only bill my insurance.
What's your level of methadone?
Like 100.
It's a lot.
But I started titrating down, but they put me on to something that I could do it quicker if I needed to.
Well, I mean, this is, I think was a second offense OVI, also a driving under an OVI suspension, pretty serious charges. He's done very little. And now he's got this common police thing.
He does.
What's the charge in common police?
The judge in common pleas.
I think it's OVI and...
Felony OVI?
Yeah, possession.
What is your hearing right here?
On that one?
Yeah.
I think the 11th, January 11th.
Who's the attorney in count, please?
Judge, I've got that case now. We're set for a pretrial on the 11th of January. Would it be, and that's our first pretrial, so I don't know if a whole lot's going to get done, but we'd possibly come back Friday the 13th of January, which is an ominous sounding day, but I'll have a better handle on trying to get a global
So you got a hearing
resolution.
on the 11th?
Yes. And if we could come back here Friday the 13th to see where we're at, I will try to get something, but it'd be the initial pretrial. I'm not sure it will be done, but at least I'll get a handle on where we're going.
I will reschedule this for January 13th, and my strong suggestion would be start getting some stuff done on this.
I'm going to direct him to probation where he leaves Judge today. That he's going to make a payment, that he's going to have some things done before he comes back 13th is what he's telling me.
Okay, time will tell. We'll see you
Yes.
on the 13th.
Good to go, just have a probation. All right, yeah.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Destiny N. Johnson, case number CRB 22-751. Destiny Johnson.
There's a cross-filing judge with Caleb Runyon, who Mr. Morford represents. And I think we have a resolution.
State of Ohio versus Caleb A. Runyon, case number CRB 22-750.
Mr. Smith is representing Destiny Johnson, and Mr. Morford is representing Caleb Runyon.
Yes, Judge, we discussed in pretrial, Mr. Morford and I did with Mr. Hill, a 90-day continuance with one court call. Assuming there's no further problems, it can be dismissed roughly 90 days from now.
Everybody's in agreement with that?
Yes.
Yes, Your Honor.
Which case when the court costs put on is?
Do we have a volunteer for the court costs?
I'll take it.
Okay. You can collect it.
Why are you?
from him.
Why are you volunteering?
She's got money.
Yeah.
And also she's
That's kind of my fault, so.
Okay. March the 10th. Date that works.
That day works for me, Judge, March 10th.
I'm good then, Judge.
Case is continued to March the 10th.
Yes, sir.
10 o'clock.
Thank you, Your Honor.
Thank you.
State of Ohio versus Brendan M. LeGrand. Case number CRA 22566.
Mr. LeGrand, I believe, is it OVP?
He is, Judge, thankfully after that false alarm we had.
Oh, yeah.
that-
Mr. Demet's online, teleconference.
Oh, yeah.
Can you give me a report on Mr. LeGrand?
Yes, Your Honor, he is currently,
Okay, your microphone cut out on you again.
hear me?
I think when you turn away, I can't hear you. It just totally goes away.
Okay, I was just saying he's currently compliant with our program. He came in here on the 29th, he's due to leave the 30th of this month. We have not begun to work on his aftercare plan yet, but we will do that in about a month.
Okay, that's gonna definitely be a necessity here, which it is for most people, so we need to be thinking about that. You said the 30th is when he's gonna be completing?
Yes, 30th is out date. I'm sure we will suggest aftercare as a overlay.
Are you available on the 30th?
Actually, I have a trial, that's a Friday, the 29th and 30th this month.
Really? What court would set a trial then?
Judge Ballard. Otherwise, he's into March, his trial calendar's getting, so he's kind of holding our feet to the fire on these trials, so, yeah. Let's see.
27th? I'd just like to nail down.
Yes, I can, that's a Tuesday, yes.
Let's do the 27th.
I guess so.
Nail down what his aftercare plan is.
That works for me, I can do that.
All right, so far so good, Mr. LeGrand. Keep working, and we'll see you on the 27th, and start thinking about your future, how we're going to deal with this once you leave OVP. We need a plan in place.
All right, sir, thank you.
State of Ohio versus Brandon Losi. Case numbers TRD 221764A and B, TRD 212268, CRB 21766, and PRC 213000 A, B, C, and D.
All right, this is Mr. Smith's case. Is that for pretrial?
Judge, he's indicated to me that he has completed community service, he's got his driver's license back, and he's an outpatient at OVP, so if that's correct, he seems to be on the right path.
Yes.
Yes, Your Honor, and he is currently compliant with our outpatient services. I have his report. So they're all negative for everything except for what he is providing. Press letters that he's compliant with all of his.
Okay, well, how do we want to proceed here? This is, it's a driving under suspension, although it is a driving under an OBI suspension, so.
There are other two that haven't been sentenced.
There's 212268, which is the driving under suspension, and then there's,
212268.
that's 212268. He's been sentenced on an OBI, which is 213000.
I also have 221764.
Yes, he hasn't been sentenced on that. Still suspended. How do you want to proceed, Mr. Smith?
Judge, I had talked to Mr. Hill, he says he will not take any position on the sentence, given that he's doing very well on what he's been asked to do.
Well, there's mandatory jail on this charge.
I realize that. Just something like
I'm looking at my notes, I don't recall that there was any kind of an agreement that we would request that the court would treat it any differently. I don't want to discount the fact that he's been in treatment, and this is a DUS case that he went to treatment on, and so I don't know whether that has bought him any extra consideration or not. I'm glad that he's doing well.
Judge, if he could have time, if the court's inclined, and I understand it's a mandatory jail sentence, if he could have a date to report after the holidays, we'd appreciate that. He's in agreement with the 72-hour jail sentence. He understands he's getting the benefit of that being the minimum charge or jail time, but he would like if he could go maybe in January, if that's acceptable.
I'm looking for I have nothing, just want to look at the facts, see if there was the facts were maybe in his favor, but the officer, from what I see, did not follow anything other than the driving record. So I don't know if you have something further, Mr. Hill, that you could look at. Have no statement of facts.
There was a crash, and there's a crash report.
On the June 27th case? So I don't have that.
Oh, no, this is from the August the 19th, 2021 case.
Yeah, the 22 case is the one that's got the mandatory jail time.
Yeah.
In the 22, I'm looking at it right, it was it.
I don't know if that makes a difference in the computer. It looks like there was an agreement, at least put in the computer, that was amended.
Let me look and see when
Well,
that.
I think,
Okay, that must have been discussed at one point.
it was, because I wouldn't have normally had to agree to do all this and then I'll have some agreement, but it looks like he was suspended from 10/14/21 to 4/12/22, and it's a failure to reinstate would be, so while it was originally an OVI suspension, I think he just never got his license back, so that might be the angle where he wouldn't have to go to jail.
I think that's right.
All right, so I think at this point then, we could go ahead and do the sentencing.
Yes.
And it is then I'll consider it amended from driving under an OVI suspension to driving under suspension.
Yes, thank you.
Is there anything you want to say, Mr. Lucy?
No.
And there is a guilty plea to the two charges that are still outstanding?
Yes, sir.
Well, you have done well in your treatment, and I want to recognize that, congratulate you on doing that, and urge you to continue to make your recovery a priority. You've got to keep working at it. So, let's start with 22-17-64, got it up. It's been amended to an M1. I'll impose a $100 fine and costs. I will do 20 days in jail suspended. I'll order you to continue with your outpatient with ODP until they say you're completed. I'll set his first review hearing. I think might go 6 months. Let's make it in February 3rd. Do your review hearing. Give you a little break. You don't have to come back until February 1st.
Thank you, Judge.
Friday in February for your next hearing. And on 21-22-68, that was also a driving under suspension. It was never charged as OVI suspension. So I'll impose a $50 fine on that. Court costs. there was insurance. Did you turn in that wreck? Was there any damage to anybody else's vehicle other than yours?
No, just mine.
Yeah, it looks like it was a single vehicle accident. Well, was there a parked car involved?
There might have been, yeah.
Okay, I'll order that you turn that in. If you didn't, you need to turn that into your insurance company. You did have insurance, it says. So the other person's vehicle needs to be fixed. Do you know if that happened?
Yeah, it did.
Okay.
Yeah, you already got a new one.
$50 fine and court costs, and that will be, and $20 from the failure to control. That'll be that. That's also set for February 3rd, and then your case numbers 21-3000, 21-766 are also set for February 3rd for reading hearings.
Okay.
There was already convictions in place.
That's fine.
Thank you, Judge.
You are.
State of Law versus Scott Taylor, case number TRC 222629. Scott Taylor.
Judge, he got a lot of miles this morning. He takes care of his mother. She is apparently very ill. I spoke with Mr. Hill about, this is our first pretrial, about having it reset. I don't think he opposes under the circumstance. I'm here the 27th of December or the 9th of January, whichever's better for the court's docket.
Okay, we better set it sooner than later.
I would agree on this case, yes, sir.
December 27th for a pretrial at the defendant's request.
Yeah, we'll waive time, thank you.
State of Ohio versus Jessica Christian, case number TRD 222505 A and B, TRD 19255 A and B, TRD 183566 A and B, and CRD 181148.
Kyle Stiles.
Set for pretrial, Mr. Smith is the attorney.
No, but I couldn't get one. Because he only had one. I thought they had faxed it. Okay. Not community service, but I called and took care to see how they had to do and people are 60 I need to make
Okay, so you're working still on the
and
license?
I have to keep SR 22 for 6 months before I can get them. There's a whole lot of here for it.
We're also restitution, which we don't have information from.
She's still working, she's got.
That's fine.
Keep on working on different stuff. Okay. Okay. We still know what's the, do you know the amount for restitution? It's like thousands of dollars. Okay. Okay. Your Honor, after talking with Mr. Hill, it looks like there's a few things left to do. Ms. Christian, one, is working on getting her license, and evidently that's about a 6-month process, is that correct?
Yeah, I have to carry SR 22 for 6 months before I can get them.
And then she still has some community service to do on an old case, but also there's an issue with restitution, I believe. We don't know the exact amount. She believes it's a little over $1,000, but she won't be able to pay anything on restitution until after Christmas. So I'm just going to ask to continue this again, and then hopefully we get some progress done. I think she has 3 more days left on community service to finish, so.
Mr. Hill?
And we don't oppose that, Your Honor, and we've been in contact with the the non-at-fault party here, Mr. Sias, to ask him to bring us estimates of his damages, both to his vehicle and maybe some medical bills. And as of yesterday, we hoped that he would come today, but he has not appeared today, so we still are in search of those figures.
After the first of the year, then?
Yeah, sure, that's fine.
What's your schedule?
The first week's kind of hectic, but other than that, I can do anything.
I didn't hear the first thing you said.
I said the first week of January was kind of hectic, so.
13th, January 13th?
January 13th. Is that a Friday or?
Yes.
Yes.
January 13th will be the next hearing, pre-trial, 10 o'clock.
Thank you so much, sir.
You're welcome.
I'm not armed, please. Thank you so
State of Ohio versus Wilburn Pauley, case number TRC 222446, A, B, and C.
Mr. Smith's case set for pretrial.
I know I got a strip for both of them. I told him that, yeah.
Do you have them with you?
No, I don't. Shit. Sorry, I'm sorry.
He's got prescriptions.
His prescription for marijuana?
Yeah, prescription for.
Yes.
All right, well, let's move it, have him bring those in.
You just want to do it Monday or a week?
I don't care.
Okay.
It's up to you.
Okay. I was afraid to bring it, but I mean.
No, you always bring a prescription with you. Your Honor, evidently, we've gotten the results back. That was a urine test, and this probably says he has prescriptions for the two things that he tested for. I'd ask to continue so you'd have the opportunity to bring it in, because he didn't bring with him today.
When can you have those?
I can bring them Monday.
Next Monday, Your
Whenever you
Honor,
want,
or
yeah.
next Friday, either one, whichever's.
So the 16th will be better.
16th, that's fine, Your Honor.
December 16th for pretrial.
Come back next Friday.
Yes, sir.
State of Ohio recalls Brandon M. Coe, case number CRV 22777.
So we're supposed to recall on the issues of bond and when the next hearing is.
No. It's a criminal matter, so it's a public. Okay. Yeah, so he's entitled to be in there. Your Honor, this was called earlier as for an arraignment and a plea of not guilty, of course, to the charge, has to be set for a pretrial. I understand the prosecutor's office has contacted the alleged victim. There is a CPO that has been issued out of domestic court, so she's requested no protection order out of this court.
Okay, that's good.
We're told that she has received an ex parte CPO. He hasn't been served on it yet. So.
Is he agreeing to abide by the protection order?
Yes, yeah. They have hearings next week in domestic court, so they'll deal with that next week there.
Okay, so no temporary protection order. When would you like to come back for the next hearing? after the common pleas hearing, I'm assuming.
Yeah, Your Honor, which will, I mean, if you want to do the last week or go into January. I mean, last week about December or January.
I would suggest either December 27th or sometime first week of January. What's,
December 27th, that's right.
that's Tuesday now.
I'm glad you said
So
that.
26th is a holiday.
Now, should I have that case number again, please?
It's 22277.
That's fine, Your Honor.
Okay.
December 27th is fine.
All right.
Just do this back a little bit, sir. So
It's code.
Yeah.
What was the number again?
277.
22?
Yeah, let's see. I'm sorry. That's a 7. 22777. Code, COE. So it's set for December 27th for free trial. And he can sign a $1,000 signature bond.
Okay. Don't discuss this.
Okay. Your Honor, we
Do not
have just a
discuss
little
this
bit
case
more
at that
information for him on this case. And I guess he's going to be in Point Pleasant?
Yes.
All right, so apparently the boys are going to go there with you this weekend.
Yes.
Now, another thing too, and I don't have any suspicion that he's going to violate the protection order, but we don't want to mess, because he hasn't been served yet, even though I guess he's been given
So
notice.
that's why I asked if he was agreeable to abide by it, because
Yeah.
he hasn't been served. an
Right,
actual order at this
so
point.
I don't know whether this conversation in court stands in place of actual service or not, but,
Well, it's acknowledgement of a service, Your Honor.
okay, then we'll go with that.
All right. You're good. All right.
Thank you. I'll be in touch.
What day are we moving it to?
December 27th.
That's going to be a good day.
State of Ohio versus Stephen Cagle, case number TRC 222660, A, B, and C.
Good, okay. Your Honor, may we approach?
Yes. This is 222660 pre-trial. It's Mr. Stratton's case.
Who is this?
I've asked to approach.
Oh, okay.
See, on, Dr. Brian Cremins, on Mr. Robbins, I'm going to send you, I did get a response from Amanda Rayburn, I'll send it to you, Mr. Cremins. She says, he's of the air too. He's got hurt, so. So I think he's counting on getting reduced. So, he can actually go to jail for up to a year. And they're recommending long-term inpatient treatment. It's not good. Do we continue to January 6th to get a report, so I want to get this, Brian, he needs to get his guys on the ball.
Cable is at PCC residential. This is a very ongoing. Doing this personnel. We know that. And then it's about I was thinking that reach for that time.
School. Yeah. I mean, I would be, usually they are to be finished, so we won't make it go. Not treat it as a refusal in terms of fine. All right, it's my understanding Mr. Cable is at TCC and
He
doing
is.
well.
Yes.
So I want to encourage that. Congratulations. Continue. And we'll come back maybe, what, in a month or so?
Yes, Your Honor, and then I'll discuss with him between now and then the stuff we discussed at the bench.
Okay.
This is recorded, so I discuss it with you not here. It's all good stuff for you, so stay where you're at. It's worked out really well for you.
January 9th?
Yes.
Will work. January 9th will be the next hearing.
Okay, very nice. All right, keep up the good work. Yeah. All right. Just go ahead. Yeah, just go. Counselor text me. Text me probably. Counselor. Oh, yeah.
State of Ohio versus Elizabeth Iguaba, case number CRB 22535.
This is Mr. Stratton's case set for pretrial.
Your Honor, I maybe approach again.
Yes. I see that there's a subpoena to Walmart, but they respond to that. All right. Unless something happens. Might be somebody from Nationwide watching YouTube channel. I am going to do that at some point. Now, obviously, we're regular.
So, well, here's a question. Will they find out about
Well, I mean, they're getting stuff brought up, because our home office is everything.
Let's see if there's another option. So let's go ahead and set it for. Your Honor, can we set this for another pretrial?
Yes, you have a preferred date?
After the holiday preferably, we have a ton of appointments coming up.
Yeah, sometime in January.
January 6th.
Yes.
January 6th for pretrial defendant's request.
Yeah, 10. Okay, all right.
State of Ohio versus Tarico Ralph, case number CRB 2296.
Your Honor, I believe Ms. Ralph is at OVP at the moment, and it looks like Bree just came on to the Blue Jeans.
Yes.
Yes, Your Honor, she is currently in our inpatient program.
And how's she doing?
And she will be continuing to Municipal.
I graduate today at 1.
Oh, congratulations.
And on Monday, I'll be going to Linda Goshen.
For sober living or inpatient there?
Inpatient.
Okay. All right, well, very good. Then we just want to continue this.
That would be my, that was my expectations. We want to come back. I don't know what sort of a time frame you'd like to look at, Your Honor.
About a month.
About a month would be 13th or the 9th.
Which works for you best.
Either day is fine for me, so if one's better for the court's calendar.
They're pretty much equal. The 9th.
That'd be fine. We'll make it exactly a month.
January 9th will be the next hearing.
January 9th, just write that down for me.
I think you're on the right track, Ms. Ralph. Keep up the good work.
Do we need to have a trial or a plea, or is this already? Should we do something, move it towards a resolution?
State of Ohio versus Robert Heft, case number TRC 2226 A and B.
Your Honor, Mr. Heft contacted me earlier in the week with medical documentation that he has the flu, which it appeared to be legitimate medical documentation. I discussed it with Mr. Heel, and we prefer not to be exposed, so we agreed that we would do a continuance, and I filled in the paperwork, and we didn't fill in a date because I wanted to consult with you on that issue. I didn't believe it would be fruitful to ask Mr. Heft to appear on Blue Jeans. His telephone reception doesn't seem to be capable of handling regular phone calls very well, let alone Blue Jeans. So I'm going to ask for a continuance at this time to a date that the court deems appropriate.
Mr. Hill?
We're not opposed to that, Your Honor.
I am concerned with him testing for gabapentin. I know he says he has a prescription, but I have learned that Suboxone and gabapentin together is not a good combination. That's known now.
Is the same physician, I guess you wouldn't know that, I was saying, if the same physician is prescribing both or what? I wasn't aware that that was a concerning interaction, but it's not.
Well, I learned that from Dr. Davies, who teaches addiction at the Marshall Medical School.
Yeah.
That can cause people can seek to circumvent the effects of Suboxone by taking gabapentin with it to get a high. So, I don't think we should wait a month.
I was going to say about 2 weeks to give him time to hopefully be no longer, what's the word I'm looking for? I'm sorry, contagious, exactly. And I will be here the 23rd.
Okay. So what? That's the way I like to spend my Christmas. December 23rd. There'll be a sentencing hearing.
State of Ohio versus Kenneth Aaron Maynard, case number CRB 17771.
Your Honor, my name appeared on this one, but I'm not aware that I'm on it. It looks like it's a sentencing on a review situation. I'm not sure if I've been reappointed or not.
I think it was actually, you were the initial attorney several years ago, and then there was a failure to appear and an arrest and had to post a bond. So I think that's why.
So I'm not reappointed then?
You are not.
Thank you, Your Honor.
It's on the sentencing docket because he has a bond. So he needs to take care of his obligations to the court. What are you doing on that, Mr. Maynard?
I need to make a payment today, and this evening, my money hits on my card at 6 o'clock, which is I'll be making a lump sum payment. And I think, if I remember right, you gave me 30 hours of community service, which is my vehicle. It's been in the shop, but I should be getting it back by Wednesday of this week, they said, so.
Okay, I'll give you another month then. January the 9th will be your next sentencing hearing, 10 o'clock. Once you get this done, you can quit coming back to these hearings.
Okay. And what time was that?
10 o'clock, January 9th.
State of Ohio versus
Thank you,
Casey
sir.
Jackson, case number CRV 22-510 and CRV 22-165, A and B.
Okay, so this is on the docket for, I think, sentencing and review. Okay, you wanted to change your plea, though, to not guilty, or is that right?
To what?
You were, initially had pled guilty, then didn't you want to change your plea to not guilty on the domestic violence?
No.
Or do you want to keep the guilty plea?
Well, I mean, you can change it to not guilty. I mean, that's what we agreed to last time.
Well, it had been guilty, but I thought you changed it to not guilty, is that right?
Yes.
On
Okay.
August the 12th, yes.
I was confused for a second.
Well, do you, but you don't have an attorney?
No.
Are you working?
Yes.
Doing what?
Tri-State Lawn and Landscape, same place.
Okay, I think you told me before that you wanted to get your own lawyer. Do you want a court-appointed lawyer?
I don't know.
How much are you making at doing landscaping?
$11 an hour for right now.
Are you working 40 hours a week or less?
Yes.
But you have children?
Yes.
How many?
One, a little boy.
Okay, you're eligible for a court-appointed lawyer. Do you want a court-appointed lawyer?
I guess.
Well, it's probably a good idea if you're going to proceed with a not guilty plea. So I'll appoint Mr. Smith, who's seated behind you, Tyler Smith. He's got a couple of domestic violence M4s pending and a review on a criminal damaging. He did his community service on that. You still have, he works actually some extra toward your fine. You still have money you owe on that old case, so you gotta get that done. I'll set another pretrial in this new case, let you talk to Mr. Smith about it.
Your Honor?
At one point, it was agreed that it would be dismissed if he would pay costs and go to counseling at NECO, but he didn't do that, and he wanted to change his plea to not guilty.
Well, I'm in counseling at PATH. I went to PATH because I couldn't get into NECO.
Okay.
It looked to me like on August the 12th, he did withdraw his plea. The court accepted that. And then we recommended a 90-day continuance, at which time he would take part in counseling. And I believe that Ms. Cremines was here and she said she was going to take part in it too. I read that now.
They're supposed to fax the paper. I don't know if they did or not.
So I don't know what's changed since then. But if
Okay.
he's receiving counseling and wants to continue, we actually have our latest contact with Ms. Cremines was back in November, but she said there hadn't been any problems at that point.
All right, well, I'll still, he's eligible for court-appointed counsel. I'll appoint Mr. Smith. You can talk with him about, see if he still wants to do the counseling and get it. I think what the state's saying, they'd be willing to dismiss it if he completes counseling. I have no report from Pat at this point. So, let's come back, let's give him a month then. And make it, is it better for you Mondays or Fridays, Mr. Jackson, does it matter?
Fridays.
January 13th. You still need to work on your old case and continue with your counseling.
Right. Well, they should have it here in the office. Well, I mean, you have a report every time that you're complying and everything.
State of Ohio versus Kenneth Kennedy, case number CRA 22763. Kenneth Kennedy.
Kenneth Kennedy, oh, he should be out of the jail. He was in the jail and waived extradition to Kentucky.
He's not on the field.
Okay. This case can be dismissed. He was apparently picked up by Kentucky.
Let me have to talk to these people.
State of Ohio versus Chancey J. Wise, case number CRB 22443, A and B. Chancey Wise.
Your Honor,
Mr. Wise got this counsel.
yeah, I don't know if he's here, but also we wanted to have just a few moments through Jasmine to speak with the families of the victims a little bit before we actually went through with the hearing.
Okay, well, let's hold up then.
Okay, they're all in the courtroom, so
You wanna go ahead?
we just need to get some documents for restitution. We can,
All right.
we also had requested the presence of state troopers that the court had requested that we have available. So I don't know whether they're here or not. And they are.
Okay, folks, come in and have a seat. We'll proceed. This is a sentencing hearing today.
Yes, Your Honor.
There's already been a plea entered by the defendant. And I have the pre-sentence investigation from the probation officer. So, Mr. Keel, do you want to go forward on the sentencing hearing?
Your Honor, if it please the court, at a previous hearing, the court had requested the presence of the Highway Patrol officers who were involved in the investigation of this. And so they're here if the court wishes to inquire as part of the sentencing decision.
Well, I would like for you, things that I need to consider, are there any aggravating circumstances? And there's aggravating circumstances set out in case law, so I need to know what their investigation showed. I mean, I know nothing about how this wreck happened, so that's what I need to know. How did the wreck happen? What did their investigation show? Was there any aggravated circumstances that the defendant was engaging in at the time of the wreck? And you folks can feel free to have a seat at council table. That's the information I need to know to do the sentencing.
Okay? Well, we have officers here to do just that. So, which one of you fellows would be the best to start?
I interviewed her and he did down to the crash scene.
Well, let's do you first. Your Honor, we'd like to call Trooper Bayless.
Okay, Trooper, if you'll step up, I'll swear you in. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth to help you God? I do. You may be seated.
Trooper, could you state your name and where you are employed?
Trooper David Bailey, the High Island Patrol Post in South Carolina.
And you are familiar with a case involving a person by the name of Chancey Wise?
Yes.
An occurrence back on April the 6th, 2022. Were you involved in that situation?
Yes, I was one of the investigating officers.
I'd like for you to tell the court, and you've heard the court's request to determine if there were aggravating circumstances involved in what you were able to determine about what caused this accident and everything that you learned. Did you interview Chancey Wise?
Yes.
Okay. And could you explain to the court what you found out?
Yes. So on that day in question, there was a two-car head-on vehicle crash, State Route 7, just east of the 243 intersection. There was a small bend in the road. Evidence at the scene showed that the defendant's vehicle went left to center, striking the other vehicle involved. Ms. Wise was taken by squad for her injuries to St. Mary's Medical Center. And during the time we conducted the crash scene, we called Trooper Williams, who's here today, the crash reconstructionist, to the scene to help us map out the scene and conduct a crash investigation. There wasn't any signs in her vehicle of anything. I know I'm trying to, for the aggravated part of things, there wasn't any alcoholic beverages, there was no odor or smell of marijuana, no drugs or anything like that located inside her vehicle. I left from the crash scene it was probably an hour and a half after it had happened, and then contacted her at St. Mary's. At that time, she was getting treated for injuries. I was able to have a body cam, covered it on the body cam, my interview with her. There wasn't any signs of impairment. At the time, I was certified as a drug recognition expert. There was nothing that stood out to me as far as impairment. Her pupils were normal, not dilated, not constricted. Her speech was not slow or slurred. She was obviously distraught, but otherwise not visually impaired. Speaking with her, she couldn't remember a whole lot. I don't know if that was just from the stress of the crash just happening, but we scheduled another time to meet a couple of days later after she was discharged from the hospital. That way it gave her time to calm down from the crash. She came to post. We conducted another interview. During that interview, I asked her questions about distractions. Did you have your cell phone? Were you using any other type of electronic device? She stated she was not. I actually took her cell phone as evidence, and that was given to the Lawrence County Prosecutor's Office. When they investigated the phone records, there wasn't any evidence that I'm aware of that there was anything that showed that she was on her phone at the time. Through their investigation, she never did admit to being distracted. She simply stated that she thought that the other vehicle may have been much thinner and she was reacting to it. Now, evidence at the scene didn't show that, and Trooper Williams can give the shed light on that. But as far as aggravating circumstances, there was none through my interviewing her or evidence that I had at the scene to prove that it was aggravated.
And her, because I understand your testimony that her only explanation as how this may have occurred, she thought the other vehicle may have been left to center.
Right. There was no statement made by her that she was looking out the window or distracted or something called not paying attention. It was simply she was reacting to that.
I don't know know that I have any other questions for this witness, Your Honor.
All right, Mr. Wisecup, do you have any questions?
Just very briefly, Your Honor. Trooper, is it true that based upon the criminal complaint that was filed, you referred charges of second-degree misdemeanors, second-degree misdemeanor level offenses? Is that true?
Because I didn't find aggravated offenses that were true.
And that was based on essentially the negligence standard under the statute. Is that true?
I'm not familiar with that statute.
Okay, fair enough. Was Ms. Wise fully cooperative throughout the course of your investigation?
She was. She came in, I asked her to come in, she came in and give that interview. When asked to give her phone voluntarily for records, so she did. She cooperated, she never did anything we didn't ask her to do.
Thank you, Trooper. That's all the questions I have.
Mr. Gill, do you have any further questions?
Do not, Your Honor.
Thank you, Trooper. You may step down.
And, Your Honor, if we may call Trooper Williams from the Ohio State Highway Patrol.
Yes, Trooper Williams, if you'll come up, I'll swear you in, please. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God? Please, you may be seated.
Trooper, could you state your name and where you were employed?
Trooper Chris Williams, Ohio State Highway Patrol, crash reconstructions for District 9.
And how long have you held that position as a crash reconstructionist?
I've been certified as a crash reconstructionist for 5 years, since 2006.
In your duties as a crash reconstructionist, were you involved in a reconstruction of an occurrence involving Chancey Wise?
Yes, I was, sir.
And you're familiar with the facts of that
Yes,
case?
sir.
And you prepared a report?
Yes, sir.
Mr. Wisecup, you have one of these already, right? Yes. I'm going to show you this group of papers here. I've had Martin Stacy do the one and ask for you to identify this. Might actually be more than one copy.
Okay. Yeah, I would say it might be something that's not involved in my report. Can we get through each page?
Well, just in general, what are you looking at there?
The first photograph taken is evidence that was located on the roadway.
Are these parts of the report that you made?
Yes, sir.
And you're familiar with that first page there?
Yes, sir.
What is the first page?
First page basically is a synopsis of what happened, date and time which it would occur. The first photograph captured its evidence on the roadway. It shows a gouge mark, and it also shows a scrape mark from the gouge mark.
What I want to do is just kind of start in general. So what we're looking at, this whole entire report, and then zero in on what you have found.
The report is basically my observation at the scene of all the evidence located on the roadway, along with the final rest of the vehicles, and from all the evidence collected, damage analysis of the vehicles, we basically generate a report as crash reconstructions on what actually happened and how it occurred.
In relation to the time when this occurrence happened, when was your report, when did you arrive there to do your analysis?
My office is at the Portsmouth Patrol Post, and I was on duty at the time this occurred, so approximately, I would say around an hour and a half to 2 hours from the time it occurred to when I arrived on scene.
So did you find that everything was basically as it was when the crash occurred when you got there?
Yes, sir.
So are you able to provide the court with a summary, a general statement of what you found occurred in the crash, how it occurred, and things of that nature?
Yeah, as the roadway where it occurred is starting to go, as you're traveling eastbound, a slight curve to the right. When I arrived on scene, there was a blue Jeep just nosed off the right side of the road, and there was the other vehicle involved that was had went off the right side of the road if you're going westbound in a rearward fashion. So it's like it had backed up off the road. I walked the scene. We tend to walk the scene beyond the initial point of impact where we find so to see if there's anything that could occur where a vehicle might have traveled off the road, overcorrected, and come back, and so forth. So we capture all the evidence. We see, I take the photographs. We have equipment, which is at this scene I used a piece of equipment. It's made by Trimble. It's a total station. It's a GNSS system, which is a global network satellite system. And what that does is it connects to approximately 12 to 14 satellites at once. And wherever I'm measuring the evidence on the roadway, it captures and pinpoints that. And then from that, we can download to a piece of software back to the office and generate a 2-scale diagram of the scene.
And what kinds of things are in the diagram?
We include final arrest of the vehicle and all evidence that we're able to locate on the roadway.
So, I see.
Yes, sir.
I want to make sure that we're looking at what you're, that's in the report.
Yes, sir.
Yes.
Yes, sir.
Yes.
Yes, sir.
Yes.
Yes, sir.
Yes.
Yes, sir. Yes, sir. Yes, sir. Those came from Trooper Bayless's report, his statements and things. And actually, the two before that, those are awake of the vehicles that's provided to me from our LCS.
Do those become part of the report?
Yes, they become part of our report.
Do these
as
become
well.
part of the report?
Those are added, those are not part of my reconstruction
All right,
report.
so this is your reconstruction report.
Yes, sir.
All right. Are you able to state, big picture, from your report, what happened?
The Jeep was traveling eastbound on State Route 7. Traveled up the center and struck a vehicle that was traveling westbound. The Jeep ended up turning to the right off to the right side of the roadway, and the other vehicle was pushed rearward and went off the roadway backwards.
Were you able to determine which vehicle would have been at fault in the accident?
Yes, sir. I determined which vehicle was left to center solely on the evidence left in the roadway. There was an impact area with a gouge mark that was located in the westbound lane, and from that gouge mark, there were skate marks leading up to the final rest of the left front wheel of the Jeep.
Gouge mark being what? What is a gouge mark?
A gouge mark is where a piece of metal, whether it be a rim or a part of the suspension, would make contact with force with the roadway, a piece of asphalt or concrete, and actually scrape it or break chunks of it out.
Was there debris in the roadway that would further confirm your conclusion?
Yes, sir. The debris field was all from the center line and north, which would have been in the westbound lane of travel.
So, which vehicle was over the line and made contact in the other lane?
The Jeep was in, that was going eastbound, was left to center.
And was that this young lady's vehicle that was left of center?
I believe so. I didn't get Mrs. Wise was not there at the time when I got, everybody had already been transferred.
But it was the Jeep.
It was the Jeep, this was the Jeep. Also, I didn't add in, I seen you have it, as part of our further investigation in our report, we do airbag control module downloads. And what that consists of is we collect data from an airbag control module of each vehicle, if it is supported, depending on the year, make, and model, which gives us information of pre-crash data 5 seconds prior to the crash. And that's also included in that, in one of the instruction reports.
Okay. Did that lend any further evidence to your conclusion?
The evidence of the airbag control module from the Jeep is consistent with it's 5 seconds prior, and being a newer Jeep, it broke it down every 1/10 of a second with the collected data. The accelerator percentage was normal as far as accelerating from I believe a mile per hour, 42 miles an hour up to 45 miles per hour, and then it indicated that there was never the accelerator percentage was never decreased, and there was no braking involved.
And that's for the Jeep?
Yes, sir. The other vehicle was downloadable as well, and it had a decrease in speed, and the brake switch showed it in the on position.
So that would have been non-at fault?
Yes, sir.
Party that showed that.
Yes, sir.
Does this document appear to be an accurate representation, an accurate copy of what you presented as a result of your investigation?
Yes, sir.
No, I'm going to ask that this be admitted as State's Exhibit 1.
Any objection?
No objection, Your Honor.
It'll be admitted.
Trooper, you didn't have any contact with the defendant here, interview or anything like that?
No, sir.
That's all I have for this witness, Your Honor.
Mr. White, prosecutor.
Thank you, Your Honor. Trooper, just very briefly, based upon your investigation as well, did you locate or become aware of any aggravating circumstances with respect to this accident?
No, sir.
And I think from reading through your report, did that report confirm that Ms. Wise was wearing her seatbelt at the time of the accident?
I believe it showed that the seatbelt was buckled in. At that time, it's not saying she wasn't, but if the seatbelt's buckled in, people tend to sometimes wear them, or they're buckled in and they're sitting on them. It doesn't necessarily, I can't confirm whether she was wearing it properly or not, but the ACM download said the seatbelt was buckled.
Okay. Thank you, Trooper. That's all the questions I have.
I've got a question. I understood your testimony was that the Jeep highest speed that it reached was 45 miles an hour, and that was from the data download?
Yes, sir.
And I believe that's the speed, is that the speed limit in that area, I believe?
I believe it's 55.
I believe it's 55 right there, too. Yes, sir.
All right. Any questions based on my question?
No, Your Honor.
You can step down. Thank you, sir. Anything else from the state?
We don't have any other testimony to present. I'm sure that maybe some of the victims are going to want to state that.
Yeah, if you have statements from the family or victims that would like.
We're also going to have some restitution to present too.
Okay. Is that an agreed, are we going to offer evidence on it, or is it agreed to?
We actually haven't spoke about that, Your Honor. I wasn't sure if there would be anything requested monetarily or not.
This is for.
Okay. But this is, we just got this, right? We just got this one. Okay. You want to show him this thing? I wonder if I showed you, so she'll bring I want to use show Mr. White.
That's just the funeral service, the final. Yeah, that's the final. Okay.
Are you going to be okay with the restitution?
Let me talk with you about that. I'm sorry, Your Honor, if I may just for a moment. So I guess my client's only concern is that, of course, there's and there is insurance coverage under certain limits, but and I don't know if anything there has been resolved, but that's her concern.
Well, I mean, if they're paid by other means, then that's what they're going to do. I still want to have the order.
Okay, so there, yeah, that's fair enough.
We can put an extra on there saying they've been paid.
Okay, that's fine.
Your Honor, we will have some restitution documents to present, which I believe will be agreed to. And I can bring those forward now if.
Yes, so we'll mark them and have them made exhibits. And the defense has seen these, do you agree that stipulate they can be entered into evidence?
Yes, Your Honor, we have and we do.
We're also aware that there may be civil actions that might, or insurance of some sort that might cover the cost of those things, and let Mr. Weisskopf know that we certainly not oppose, there's no windfall involved. We just want to make sure that
All right, I'll mark these 2, 3, and 4, each one separately. It states exhibits 2, 3, and 4 are admitted into evidence.
I'm sorry.
I admitted your documents.
Thank you, Your Honor. Your Honor, there are family members here that may want to make a statement to the court, and I would, on behalf of the state of Ohio, state first of all that, this is second-degree misdemeanor is what was charged based on the evidence that was obtained from the reports, everything that was gathered together by the Highway Patrol to determine exactly what the situation was. And what was charged, we understand, doesn't seem to come close to the grief that's been caused and the tragedy that's been caused. So our feeling is that the family members involved in this, the ones who've incurred the loss, are best to speak to the court as to what they believe the sentence should be. And so we want to invite any of the family members who want to come forward and speak to do that at this time. And I don't know who wants to go first, but
we have two families, two victims here, Ms. Labor and Mr. Blankenship, I believe. Is that correct?
Yes.
So I'll hear from any family member or other person that feels like they're victimized by this they want to make a statement to the court.
And this is Nikki Lyons. She's Nicole's mother.
Do you wish to have her sworn, Mr. Weisskopf?
I don't know there would be a need for that, Your Honor.
All right, ma'am, you can make an unsworn statement. You don't have to be sworn in if you want to just make an impact statement.
But I'm going to try to read.
Okay. And can I get the correct, I want to get your name correctly. Can you spell your name, please, ma'am, for the record?
Nikki Lyons, N-I-C-K-I-E, L-Y-O-N-S.
Thank you, ma'am. Go ahead.
I'm here today on behalf of my daughter, Shannon Nicole Weaver. I have to speak on her behalf because on April 6, 2022, I lost my only child due to Chancey Wise's negligence. She was unable to control her vehicle and caused the death of 2 innocent children. She's ruined families and caused myself to be in therapy for severe trauma. I believe Chancey should be held accountable by all means necessary. She should be getting more than 2 misdemeanors. I believe this case should be turned over to the grand jury. She was unable to control her vehicle and was 5 feet in the wrong lane going 50 miles per hour. Myself, her father, and Tony Blankenship's family will never get to see or talk to our children again. A parent should never have to bury a child. I cannot begin to explain the pain and suffering I have and still am going through. Private justice is not being served in this case at all. His lives were taken, and 180 days in jail is not justice. My daughter was only 19 years old. She never got to live life or get married or have children of her own. That was all taken from her. I still don't understand how vehicular manslaughter is misdemeanor. I don't understand why the 2 deceased were drug tested, but Chancey was not. I know the ambulance got there first and administered Chancey with medication, but why couldn't they have drug tested her and omitted what the EMTs gave her? How do we know that she wasn't driving under the influence? There are many things in this case that don't make sense to me. We will never know what actually happened that day, but Chancey knows. I will never understand. I just don't know, and I want justice for my daughter. She was just starting life, and that was all taken away from her due to Chancey's negligence and inability to control her vehicle. I'd like to know how someone ends up 5 foot in the opposite lane without being distracted. So I'm asking please to consider more jail time without the option of an ankle monitor. Thank you for your time and consideration. Sincerely, Nicole.
Thank you, ma'am. I'm very sorry for your loss.
Your Honor, this is Shane Blankenship, and he's an uncle.
Uncle of Mr. Blankenship?
Yes.
S-H-A-N-E?
Yes, sir.
All right, Mr. Blankenship, you can go ahead and speak.
I didn't write anything down. I don't know how to go about doing this. Speak on behalf of the family best I can. The dad can't talk, and the mom sures, hell can't say anything. His brother's wanting to talk, but I don't know if he's gonna be able to either. We've already been told that she'll not spend a day in jail, which is absolute slap in the face. Not only did she take the life of our boy, but she destroyed their family too. Thanksgiving rolled around and she was able to sit at the dinner table and enjoy her Thanksgiving dinner with her family and give thanks for what they had. We didn't, and they did. Christmas is coming, and she's going to be able to sit with her family and give thanks for what they got, but we're not going to be able to, and neither is her family. But she'll never spend a day in jail. I lost my best friend. He lost his boy, and she lost her baby. He lost his brother. She lost her daughter. He's got a brand new little niece sitting there he'll never be able to see grow. They say that there was no distraction. And I know you've been through that road right there. And in that little bend right there, and you come 5 feet over. What was you doing? There's no distraction. What was you doing? That's a straight stretch basically right there. You can see all the way around that curve. What were you doing? You wasn't on the phone. What was you doing? Something happened. You know? And, I think it's sad. I mean, it's very sad that I know she's heartbroken. I know her family's heartbroken. I understand it. But when all this is said and done right here, and you lay your hand on the table, she'll still go home. And there's 2 families right here for the rest of their lives going to be destroyed. You know? That's really about all I really got to say. This is.
Thank you, sir. I'm sorry you're going through this and your family too.
I think his brother really wanted to say something. I don't know if he's going to be able to or not.
This is Cody. State your name, please, sir. Cody, can you spell your first name?
C-O-D-Y.
All right, Mr. Blankenship, you can go ahead.
Day of the accident, I was actually one of the first ones there. It was me, then my brother. I myself had to swerve.
You were following them, or?
He was following behind me.
Oh, okay.
And he met up with us at the curb. And I had to swerve for her not to hit me. So not only did she hit my brother, she almost hit me too. And to deal with the PTSD that I have and the flashbacks and stuff of that day, of watching my brother take his final breath and watching his girlfriend take hers, I cannot enjoy what a lot of people can anymore. I went to the fall festival here in Chesapeake. The sirens started going off. I went into a full-blown panic attack. I can't enjoy the small things that I used to be able to. And I have an 8-month-old daughter that will never know, that my brother will never be able to actually know and watch her grow because of her negligence and all that. I do think, I know there's a maximum penalty that has to be set forward in this manslaughter. I think for both cases, it should be that. Because like my uncle said, you know, Christmas is coming around, and while everybody else will be able to enjoy being with their family, we'll have one empty seat at the dinner table that day. I just hope this will be served today.
Thank you.
Is there anybody else? This is Kathy Mance, and she is Mr. Blankenship.
And you come forward. Would you state your name for the record, please?
Kathy Nance.
Kathy with a C or K?
C.
And the last name?
Nance, N-A-N-C-E.
Thank you. You can go ahead, ma'am.
The day that my sister called me, never forget it, I was at home. She was sitting there alone with the baby. She wanted me to go check on her son because he just had a wreck. I get up there and it is something that nobody should have to look at. Nobody should have to see the vehicle, the damage that was done to that vehicle, to know that he was still in that vehicle when I got there. To watch my older nephew go through everything that he had to do that day and still take on the responsibility of trying to talk to the police, to tell them what happened, and plus deal with what he had to stay there and face before everybody got there. That is insane. There should be nobody that has to do that. My sister, I had to go and comfort my sister. How do you tell your little sister that her baby died? I mean, how can you do that? How can you just go and like, look at somebody who's broken, the mom, the dad, the nephew, the uncle, the niece. She'll never get to know her uncle, the sister-in-law, his cousin, his grandma, my children. Like, it's just a trickle effect. Like, there's so many people that's going to miss him, and you're never going to get anything back. He was 20 years old. His birthday is next month. He will never get to see the 21st birthday. They'll never get to see his grandchildren, their grandchildren from him, or anything else. Why is that so easy to say it was a misdemeanor when she took 2 lives? As they said, the holidays are coming. They can't celebrate like they do. My sister didn't even want to put up a Christmas tree, but they did because of the baby, to try to make life feel a little bit normal, to be able to function every day, to get through the holidays because of that. I think that there should be something there that she has to be punished to remember whatever happened in that vehicle that day, that maybe she might decide not to do it again. Or maybe she could pass on what happened to her when she didn't pay attention while she was driving a 1,500-pound vehicle and crashing into somebody. Like, I go through there all the time, and I have to literally see that crash light every day. When I go to work, when I go to the grocery store, I have to see that big white cross that sits there with 2 people's names on it in the exact same spot that the car stopped in. And I have to see it every day. She doesn't have to go that way. She doesn't have to be reminded that going through there is the spot where she ended 2 people's lives that'll never need to be the same ever again. So I think you should probably take into consideration the families back in there of what happen whenever you decide to give her hers for her crime.
Thank you, ma'am. Anyone else?
I believe that's everyone, Your Honor, unless anybody else would like to.
Okay, I'll hear from the defense now if you wish to offer anything. Mr. Weisskopf, or on behalf of the defendant?
Yes, Your Honor. I think I'd first ask if my client could give her remarks. Would you like for her to do that here or up here?
Wherever she would like. She can do it from there or on the stand. And this is Chancey Wise who will be speaking next for the record.
To start off and say that I'm sincerely sorry for all the families that were involved in the accident. We question every day why it happened, the way it happened, and quite frankly, I don't think I'll ever be able to wrap my mind around that. See, everything happens for a reason, but you know one can look at me in the face and say that this happened for a certain reason. All anyone ever sees is me, what they would say is me living my best life, but no, what people see is me trying to mask my feelings every day. From the half second that I open my eyes in the morning is the best time of my life, because the minute my feet hit the floor is a distraction after that. Every day of my life is a living hell because of this. I'm suffering too because of this. I question every day why I even made it out of that, but I shouldn't have. There's no reason that I should have made it out of that. No one sees the daily panic attacks, the sleepless nights, the multiple days that I go without eating because I just can't. I'm disgusted. It's a struggle for me to step foot out of bed in the morning. And I completely understand the pain that I put you guys through, but I am sorry. With all my heart, I am sorry. I don't just go out and I have the best time of my life all the time. This has been the absolute most difficult thing that I've ever been through. I can't bring myself to even eat most days. The multiple psychiatric medicines that have been thrown at me, the multiple psychiatrist appointments to even deal with this, and nothing helps. I've seen wrecks like this from an EMS side, from a fire department side, and when I work in the ER. And there's absolutely no reason that I should have made it out of that. And I'm sorry that I did, because I shouldn't have. Again, I'm really sorry. I don't think I'm the 20-year-old that just got lucky. I'm now the 20-year-old that has to live with the fact that I caused two families to lose two of their children, and I really cannot live with myself like that anymore.
Anything else from the defense?
Just a second, Your Honor, if I may. Your Honor, Ms. Wise's significant other has asked if he could also offer a few remarks for the court. He's present here. If he
His name?
Robert Shepherd.
All right, Mr. Shepherd, why don't you come up? How do you spell Shepherd? Because there's different ways.
S-H-E-P-H-E-R-D.
Mr. Shepherd, go ahead.
Your Honor, my name is Robert Shepherd, and I'm here on behalf of Chancey Wise as a witness to her character. I met Chancey right after the accident and have been in her life every day since then. I'm a firefighter, EMT, K-9 handler for the Sheriff's Office. So in my profession, I'm aware of PTSD, survivor's guilt, and I'm very familiar with what that looks like.
In my time with Chancey, I've been there through the nightly crying sessions, the panic attacks, having to take her out of Walmart because you just can't function like that anymore. The sudden flashbacks she has, the night terrors that she has. I'm witness to the pain of a woman that was involved in an accident. However tragic, it was an accident. I'm also a son, sibling, uncle, father. I cannot even imagine the pain that you all must be going through. But I'm here as a witness to tell you that she's not just going out and not feeling pain also. Chancey has been, at times, reconsidered her career path as a nurse, reconsidered her career path as in emergency medicine because of the trauma that she's been through of seeing this. I'm also here to testify that Chancey is a contributing person to society. She is an EMT, a phlebotomist, an EKG tech, worked in the ER. She worked in the ER during the worst time. She worked on COVID units during the worst time of COVID. She is somebody that continuously tries to give back to the community, tries to give back to society. She is a person that continuously, like many of us in the room, she is a public servant, and she tries every day to give something back. She spends every waking moment giving back to the community and humanity. She's not a menace to society. She does everything she can to be part of the community. She's a person that sets the bar higher than her expectation and doesn't settle for mediocrity in her life, in public safety, in public service. She's the true definition of a public servant. But I believe she's also a victim of this. That's all I got.
Thank you. Anything else?
If I may, just briefly, Your Honor.
If you're going to, I would like to hear from the state what their recommendation is before you.
Yes, Your Honor, yes, we don't have any further witness.
Mr. Hill, does the state have a recommendation to the court as to sentencing?
Your Honor, if it please the court, and the reason that I was happy to have the families of these individuals speak first is because they're the aggrieved individuals in this, and I think that what they've said speaks pretty clearly.
But they're not lawyers, so
I understand that.
The position of the state of Ohio as to what the sentence should be. I mean,
Well,
that's the usual course.
And that's what I'm preparing to do. However, I wanted to make clear that I feel that their words speak as, I can't come close to expressing my feelings on behalf of the state as clearly as they have. They believe that there should be substantial jail time. From our perspective, we understand that what she's charged with and what she's pled guilty to is a misdemeanor, and that it doesn't measure up to the grief that they're feeling. We heard from the Highway Patrol, 2 officers who we know take these matters very seriously, and I believe investigated every angle of this to determine if there were aggravating circumstances that might have warranted a more significant charge. So we ended up with what we did because we try to follow the law as clearly as we can. And we believe that under the circumstances that the maximum jail sentences should be ordered, and as to whether there's a period of time actually imposed at this time or deferred based on her future behavior, we would take no position on that.
Mr. Wiseman.
Thank you, Your Honor. I would just say I've gotten to know Chancey over the course of my representation these last months, and I have to say she's somebody who has impressed me just with her maturity. She was 20 years old. I think she's just turned 21, but you know, she's handled this with as much grace as you could expect from somebody her age, at least on the surface of things. And as you can see, Your Honor, I mean, below the surface and even on the surface today, you can see the kind of pain that she's dealing with. I can't imagine anybody handling it better than she has, but unfortunately, Your Honor, she will have to carry this with her the rest of her life. I can't imagine. I mean, you heard it from her. I can't say really more than that, but it's extreme grief, extreme just survivor's guilt. She questions why she made it out and others didn't. And those are things that she will have to carry with her throughout the rest of her life. She is in treatment, she's seeing counselors, she is prescribed medications to help deal with the anxiety, the depression, the post-traumatic stress disorder, other conditions that she's been diagnosed with as a result of this. And that's probably not going to change anytime soon. That's something that she's just going to have to continue to carry with her. As she says, every moment she opens her eyes, that's present on her mind and probably will continue to be. I know it's easy sometimes to, when an attorney's advocating on behalf of their client, it may seem as though it's minimizing the other side of things. I don't seek to do that in the least. I certainly acknowledge, as is Chancey, the grief and the pain and the suffering of all the families. This is a tragedy for every single person involved. It truly is. Everybody who's been touched by this tragedy. Life has forever changed for every one of them, including Chancey. And again, we acknowledge and are sorry for the pain that this has caused others, the families that are involved. Your Honor, with respect to sentencing, we would ask the court not to impose an active sentence of incarceration. We would ask the court to consider a probationary sentence, a sentence that would take into account other means of allowing Ms. Wise to atone for what's happened, whether that be significant community service or other conditions that the court thinks are appropriate. Ms. Wise has been said, she's a paramedic, she's an EMT, she's in school, she's in nursing school, she's been a firefighter, she's seen things from the other side of this, and she's a person who honestly has given back and will continue to give back to the community if given the chance. And we ask the court to take all those things into consideration in making a sentence at this point. Your Honor, I don't know, there's no way to adequately account for what happened. There's no way to undo what's been done. And honestly, Ms. Wise will suffer with this and continues to suffer with this each and every day of her life. I'll also say, Your Honor, that, as I think we heard from the officers, this was an accident. I believe it was charged as an M2 on the negligence standard. There's no evidence that there was any aggravating factor involved. Since I've been involved in this case, honestly, many times I get behind the wheel of the car and I think about this case and I think, this could be me, this could be any of us. One accident, one overcorrection, one mistake, and lives can be taken. But for the grace of God, so go we. And so, Your Honor, we ask that you take all these things into consideration, what you've heard from Ms. Wise and others, in imposing the sentence in this case. Thank you, Your Honor.
Thank you. Well, let me just first say how awful and terrible this all is and how inadequate I feel to balance the scales. There's no balancing the scales, and you've probably seen Lady Justice holding the scales, and that's one of the roles the court has, is try to balance justice, mete out justice, and there's no way with 2 deaths here that there's any way to give justice in that sense. There's nothing I can do that will bring your family members back. And I'm so sorry. I wish I could put you back, everyone, to April 5th, and we hit the reset button and not have to go through this, but there's no way to do that. I want to explain my thinking, and some of this is legal words, so it may seem foreign to you. The lawyers will understand more about what I'm talking about, but our system comes through the English system, and the intent of the person is really important in our criminal justice system. Mens rea is the Latin phrase to describe. It means evil intent. So the more intent somebody has, the more culpable, the more bad we think that is, and the more it deserves punishment. If somebody intends to hurt someone else, then that's really bad. If someone is, and that's one of the things I was looking for here, and I don't go out and make the evidence, I only get to sit here and listen to the evidence brought to me. There's no evidence here presented to me that implies evil intent. And that can be, evil intent can be as much as on the cell phone. Because when you get on the cell phone, that's a willful thing. You're getting on the cell phone knowing, that happens a lot. People get on the cell phone while they're driving, knowing that that's distracting them, but they're willing to put everybody else on the road at risk so that they can text or they can call somebody or whatever it is. That's some mens rea. It's not like a murder where you intend to kill someone, but it is some indication that this person had some intent that at least put people at risk. Drinking, voluntarily taking alcohol or drugs into your system and then get behind the wheel of the car. That's some evil intent, because you know at least you're putting people at an increased risk of harm. And we can call that reckless in the law. We call it reckless conduct, gross negligence. But the only evidence I have here is pure negligence. It's what we would call in the law, pure negligence. And what is negligence? Not doing what a prudent person would do. That's all negligence is. Not doing what a reasonable, prudent person would do. And that's keep your car in your lane. Was there more going on? I don't know. If there was, the evidence hasn't been presented to me. And that's what I have to go off of. And in most of our history, negligence is not criminally culpable. Now, it is under this statute, but it's the lowest level. That's why it's charged as a misdemeanor. If there had been evidence of drinking or some other conduct that was more willful, more of a mens rea, then you would have a higher level offense charged. And I'm assuming that's why the state, because they didn't have that evidence, charged to the level that they did. So, I know folks want to have the maximum jail time imposed, but I don't believe that I should do that. I don't think under the law it's right for me to do that, because it's pure negligence. I am going to sentence Ms. Wise. The maximum is 90 days, so I'll sentence her to 90 days on each count, but I'm going to suspend it on the condition that she does 1,000 hours of community service, and that's a significant amount of community service. 1,000 hours of community service on each case, so 2,000 hours of community service. That's a year. That's basically a year of full-time work of community service. And that's not going to satisfy anybody on the side of the families that lost someone. It's not going to change things at Christmas, and I understand that, and I'm so sorry. I wish that I could. But I think it's the appropriate sentence with the facts that are presented to me. I am also going to order her to pay the restitution amounts that were put into evidence. And I believe, it's my understanding, that there was liability insurance coverage. And that should take care of that. There is, you have the option, and again, speaking to lawyers, they understand this. There's civil actions and there's criminal actions. The families have a right to a civil action. You can sue Ms. Wise for civil damages. And if you haven't investigated that, you need to investigate that. You've got a 2-year statute of limitations. You have to bring your claim within 2 years. And that you can get not only the restitution amounts, but then pain and suffering and mental anguish, and those kind of damages are awardable in civil action. I can't give you anything for those in a criminal action if I wanted to. Mr. Wisecup would appeal me to the Court of Appeals and they would reverse me because I'm not allowed to consider that in a criminal action. So I wish there was more that I could do. I wish that I could fix this. I can't. I think my job as a judge sometimes is to do what I think is right. I have to look at myself in the mirror, and 90% of the public may say, we think you're wrong, you should put her in jail. I'm sure this side of the courtroom thinks that. But I have to do what I think is right, whether people agree, whether it's popular, unpopular, whether we don't have a vote on what's the right thing to do. I'm going by precedent. I've actually looked at some of the case law on this. That's why I wanted to have the officers here, because I knew I had to know what the circumstances are. And I don't investigate these cases. That's not my job to go out and investigate cases, get the facts. The prosecutor brings me the facts. The defense can bring facts, or they can challenge the facts that the state brings, but I have to rely on the facts that are given me in the courtroom. And I'm making my ruling based upon what I think the facts and the law are. Again, so sorry that we have to do this. So also, Ms. Wise will be on probation for 2 years, and I'll set a review hearing in a few months where I want to see some work done on this community service. I want you to meet with Mr. Cooper today. He's in charge of community service. And, we have a regular community service program here at the court we can use that. And I might be open to her volunteering some for if she has some services she could render with using her medical background. I just gave blood at the Red Cross, and I know they had volunteers there that helped them in blood drives and that sort of thing. We have a great loss. This isn't going to balance the scales, but let's have her do something that's good for the community to pay back. It's not going to pay back totally, but it's at least a symbolic payback. And I think that's what we have to do here. So I will prepare an entry putting into words the things that I've set forth today. And let's set a review hearing. That's the way this court works, to make sure people are doing what they're supposed to do. They come back for periodic review hearings, and then I check to see how they're doing on their reviews. And that's, if Ms. Wise doesn't take this seriously, doesn't come to her review hearings, doesn't do the community service, then she's going to get the jail time. That's the way that works.
Your Honor, there's one other thing too, and that is that there is a mandatory Class 6 license suspension of 3 months to 2 years.
Okay, I'll make it 2 years at this point, and if, that's something we can consider down the road. At this point, I'm going to make it a 2-year suspension.
That'd be fine. Would she qualify for privileges under that suspension, Your Honor, for purposes of work and school?
Mr. Hill.
Well, the court's ordered a substantial amount of community service, and we want her to do that, so that probably would be a good reason to allow it. And if the court feels that, she has a career as well.
Okay, I'll allow her during the time of suspension to drive only for community service and to go to work, and she's in school, she can go to school. Where are you attending school?
Right now I'm at OU Southern in Ironton.
Okay. That will be in the entry. I haven't set the review hearing date. I'll make the first hearing February 3rd. Your first review hearing will be at 9 a.m. And those are open to the public if anybody wants to attend it. Anything else from the lawyers?
No, Your Honor.
No, Your Honor. Thank you.
All right. See Mr. Cooper, and then you're free to go, Ms. Wise. And I know there's a lot of emotion. I don't want any outbursts or confrontations.
Thanks.
We still have cases to do, so we'll continue on with the court's docket.
Anything else?
No, but thank you very much for being here.
You're welcome.
Let me know if you need that.
We're going to start preliminary hearings now. Let's just come back to those entries later. I'm going to have to review them pretty closely.
State of Ohio versus Stanley B. Bennett Jr., case number CRA 2646, TRC 2015-22, A and B. Stanley Bennett.
This is Mr. Smith's case. He had already entered a plea, he was supposed to be going to treatment.
That was my understanding, Judge. I've got no idea why he's not here.
And he has a bond up.
Yes, OVI,
Yeah.
for a charge.
Judge, if a warrant issues, I would ask it be held for 7 days.
Well, he's got a warrant.
Oh, that.
He's got a bond up.
Yes, well then Gary, I'm assuming it's Mr. Sowers, can find him for us. I don't know why he's not here.
Okay.
I really thought we're just here to see how he's doing with his treatment, see where he's at.
Okay, I will send a copy of the warrant, or the bond to Mr. Sowers.
Okay.
Is there a bond for Tuesday, Your Honor?
Yeah.
Yeah, let's make it January 9th.
Waived grand jury.
So I'll issue a warrant today for failure to appear.
State of Ohio versus Clayton Defendant, case number CRA 22684, CRA 2212, CRB 21823, CRB 21699.
May I correct, Your Honor?
Yes.
Hold on for a second.
I'm just thinking.
Okay. Okay, it's a good report, but recommended they continue on.
Yes, sir.
Assuming he's in agreement with that.
Yes, sir.
And is Clayton Demina of Proctorville your father?
No, he's Clayton Ramey.
Okay.
Yeah.
I knew a Clayton, well, I do know a Clayton Demina of Proctorville, I know that.
I ended up with my mom's last name.
Okay.
One of them stories.
What's your schedule in January, Mr.?
Judge, I'm here, excuse me, the 9th, 13, 20, or 27.
13th.
Yes.
January 13th. for preliminary hearing and pretrials on misdemeanors.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
Thank you, sir.
Keep it up.
Gotcha.
State of Ohio versus Stephen C. Cart, case number CRA 22667, A and B.
May I approach, Your Honor?
Yes. That's a good report from Mr. Carter.
Thank you, Your Honor.
Good job. Let's continue on then and make it a little further out before he has to come back again. About January 27th.
That's fine, Your Honor.
Thank you, Your Honor.
Good
Thank
job,
you again.
Mr. Carter. Keep it up.
I'm very grateful for the opportunity, sir.
I'm glad you're taking advantage of it. Thank you for doing that.
Yes, sir.
State of Ohio versus Robert Myers Jr., case number CRA 22489, A, B, C, and D, CRB 22488. And case number TRC 222120, A, B, and C.
It's Mr. Morford's case. Come here and here.
Judge, may I approach? I have a letter from New Life Recoveries.
Yes. Sorry, maybe short. That's fine. Very good report, sir. Thank you.
Thank you.
Back to working full-time and got good reports, good screens. That's, I give you an A+.
It's been tough, but I got it.
Okay. I think we need to keep going though.
Yep.
Not finished yet, so let's go out maybe 6 or 7 weeks before he comes back now. January 27th.
I'm good, Ben.
January 27th will be Mr. Byers' next hearing.
Thank you, Your Honor.
Thank you. Keep up the good work, sir.
No, got to.
State of Ohio versus Jesse Scarberry, case number CRB 22615, CRB 2781.
This is on the trial docket today. The bailiff tells me he thinks there's been a resolution.
Your Honor, is that there's no victim, and my understanding is that she's spoken to Jasmine about earlier. She wanted to not pursue it, and she hasn't been in any contact since then. She's not here today, so.
Here's the first charge that we have was several months ago in 2020. There was one charge and then another one after that, but in the interim, having had the victim, Ms. Scarberry, here on several occasions and stating her desire for the case to be dismissed, It was our position that Mr. Scarberry should do anger management counseling. And I thought he started doing the anger management counseling, and at some point we got a report that he was no longer doing it. And I think it had to maybe do with the fact that he wasn't able to do it at Riverside. I don't know whether it was he decided he didn't want to do it, but
He didn't qualify.
didn't qualify. Okay, so then the next step was to set it for a trial today. Well, we had not had contact with Ms. Scarberry even before that day, and she has not appeared today. And what we would like to do, we were going to dismiss the case once he finished the counseling. He apparently did not, they didn't find a need for the counseling. So what we would like to do is nolly the case with the right to refile it if she comes forward and says, I didn't want it dismissed.
Cases will be nollied.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kevin Pine, case number TRC 22-2480, A and B.
Mr. Morford's case is on the docket as a sentence. He's in brighter days, or he was. He still is.
Still in.
I have a report for you, Judge.
Okay, yes. Okay, this is an excellent report. It says negative on screens, positive outlook. He's going above and beyond expectations. He's excelling in the program. Kevin is exceptional, doing well in the program. So, doesn't get much better than that. So, good job.
Thank you.
Do you have any idea how much longer the program is going to last for you, or are they giving you any end date? Or?
Not a clue. I know I learn something new every day I go, and a lot of stuff I didn't know about myself that I needed to know.
Okay. Well, I suggest we keep doing it then. So
Yes,
if that's
sir.
the case, and then we'll, eventually we're going to get a sentencing, actually do a sentencing, but, with these kind of reports, I'm going to do as much as I can to give you all the benefit of the doubt that I can on the sentencing. Mr. Hill?
We agree that we're encouraged by his progress in treatment. We want him to continue to do that. One of the things that I was looking at too was the fact that at the time it was put on the ticket that he did not show proof of insurance, but I think maybe there's some other situation.
Yeah, that would have been with Armstrong's. It would have been in the blue envelope. I don't think they even asked me for it.
Okay, so.
But I've got my insurance, personal insurance for my vehicles with me as well today.
Okay.
Says you and a computer, I don't know what it says on the citation.
It says none, no proof. Do you have that proof today? Or?
I have my insurance for my personal vehicles, yes. The incident occurred in Armstrong's company vehicle.
Well, as long as you have proof of insurance, I think that would satisfy the B and B. In Ohio, you have to be covered, and you can be either covered by the insurance that's on the vehicle or the insurance that you have. So
Okay.
now, if there'd been a wreck, those two insurance companies, as their want is, because they never want to pay anything, they would get in a huge fight as to who would have to pay. But at least you had some coverage, so we can tell the B&B, because they're going to suspend you if we process this and send it in. So no, he didn't have any proof of insurance, they're going to give you a suspension. So have you got your card today?
Yeah.
You can pull out.
There was a crash and it
Oh,
hit a
okay.
guardrail, so it's a state of Ohio guardrail.
Two
Yes.
vehicles, technically three, but those are the ones I drive.
Do you know if there was ever a claim made by the state for the damage?
Not a clue, sir.
So here's a nationwide insurance card effective August 19th of 2022, and it goes through January 2023, so
Can we have a copy of that for the file in case the state's...
I will make a copy for you, Judge.
All right, the clerk can show proof of insurance was shown in the courtroom. That's it, I need to set another date, too. So Mr. Pine, what's best for you in terms of dates to come back, Mondays or Fridays?
Fridays.
February 3rd?
I'm here then, Judge.
Okay, maybe then we can get close to wrapping this up. February 3rd is a sentencing hearing.
Okay.
Thank you, Your Honor.
You're welcome.
Thank you, sir.
You're welcome.
State of Ohio versus Jeremy McMillan, case numbers TRC 22-762, 769 A, B, and C, TRC 2024-10 A, B, and C, TRC 14-2341 A, B, and C, and TRC 14.
He did not check in, Your Honor.
Thank you.
He did. He had a dentist appointment out of town. I forgot to ask this to be reset. He's at the Craddock House. Is he doing well?
Yes, sir, he's doing well.
He did call Judge and totally.
Ms. Stevens, right?
Yes, sir.
Yeah.
First name I've already forgotten.
Kayla.
Kayla, okay. I told you it'd take me a while to remember, but I remember the last name because I've got some relatives there, Stevens. When do you think you'll be available?
Judge, I'm here 27th of December, a couple weeks, or the...
Okay, we can do it then.
Is that,
December
okay.
27th.
Surely it'll be done by then. But he did call, and I just forgot to even ask it to be reset. Okay, thanks.
Finish with class, continue to
Yes.
December 27th.
Wait time. Well, it's on sentence, you know. But if we do, I will.
I'm used to filling them out.
I know.
State of Ohio versus Stephanie Plumley, case number CRB 22584. Stephanie Plumley.
This is set for sentencing.
I didn't realize it. I'm sorry. Your Honor, she came to us and asked for a random screen because she knew she was going to have to screen. That is in the folder.
I haven't.
Okay, I just want to make sure.
My paperwork, he's got it. Yeah.
Are you still at Mountain State?
I'm with both Valley Health and Mountain State.
I'm sorry?
I'm with both Valley Health and Mountain State.
Okay.
We've got a report she's handed over to me from Mountain State, which I'm assuming this is your only copy. but-
No, I've got copies too. That one's for y'all. One is from Valley Health and one is from Mountain State.
Okay, I can bring those forward, Your Honor. It looks like she's engaged in therapy with Mountain State.
She took a screen today, so it was problematic. We need to change things up a little bit because your results today were not good.
Yes, sir.
Where are you living?
Beach Fork, Wayne County.
Oh, okay. And Valley Health is out, there's a Valley Health out, is it at Wayne or?
Yeah, there's one at Wayne. I see Amber at Valley Health.
Okay.
I went twice, and then my next appointment's the 13th.
Are you on any kind of medically assisted treatment or?
No, not yet. I'm
Okay.
on no kind of medications.
Well, I don't know if it would help you with what you're taking, what you tested for anyway, so, but the methamphetamine's a big problem.
I did pretty good up until like the 29th. I think it was like the 30th whenever I used, and then I haven't used since then, so I'm doing better with that. Doing a lot better. I can tell a difference in it. And my therapy and stuff that I'm doing.
Do you have a West Virginia medical card?
Mm-hmm.
That's how you're getting treated?
Because I go see Amber, and then I go see her twice a month. I think it will start, I think that's what she said. And then I go to Mountain State twice a month.
Okay, well, I'm going to send your screen results to Valley Health.
Okay.
And we need to make some changes, obviously. Get you back where you need to be.
Okay.
And is it Amber you're seeing at Valley Health?
Yeah.
Okay, I want to see you back in 2 weeks, and I want a clean screen.
Okay.
Can you do that?
Yep.
That's the 23rd,
What time?
10 a.m.
Thank you.
You're welcome.
State of Ohio recalls Kevin Pine, case number TRC 222480 A and B.
Your Honor, Mr. Pine asked me to have it recalled to see if he would be eligible for work driving permit.
Yes. You want to prepare one, outline for work?
Yes, sir.
Treatment, what else?
Treatment, kid to school, and kids' doctor's appointments.
Okay, child care.
Where he's disabled, he has therapies 3 days a week, and we actually has to go to Cincinnati on the 19th for doctor's appointments at the Children's Hospital.
Okay, if you'll prepare an entry, I'll execute it, Mr. Morford.
I will. Thank you, Judge.
All right, thank you.
Yes, sir.
State of Ohio versus Edgar Stowe, case number TRD 201733. Edgar Stowe.
This is for sentencing, Mr. Stowe. You've got community service and fines and costs. And it looks like you did some recently?
Yes, have everything done.
Your Honor, I have not received the community service. He has told me he's done it, but I have not received it.
There is something in the file from Rick Sturgill at Real Life Ministries, so.
He did call, and I did tell him I will approve that.
Okay. And it looks like yeah, it looks like you've got 30 hours. And make payments too. Okay, you're completed, sir.
All done?
Your case is completed.
Thank you, sir.
You're welcome. Okay, we're going to start our teleconferencing with the jail.
Lawrence County Jail, State of Ohio versus Shannon Badalamente, case number CRB 2325.
Mr. Morford's case set for pretrial on review. She's also got a holder from common pleas.
Yes, sir.
Well, she didn't die, so I assume she got detoxed at the jail.
I guess she didn't get accepted at OBP.
That I don't know. They had at one point said they would take her, but common police had a holder on her.
That may be the snag.
I think that is it, or it was it, unless that's changed.
I know I spent a substantial period of time on the phone with the adult probation office trying to get her an ankle monitor, and they weren't even going to look at it until this past Monday. And I haven't heard anything from them.
Ms. Badalamente, have you been to common police court yet?
No, I can pay for my own ankle monitor.
Well, the problem is, I would let you go to treatment, but you got a holder from the other court and they haven't approved it. So as long as they're saying keep her in jail, you're gonna stay in jail.
All right.
So do you know who your judge is?
Finley?
Yeah, well, you'll have to talk with Judge Finley about letting you go to treatment. I've already approved it.
All right.
So let's set another hearing.
I believe she goes Wednesday, Judge, in front of Judge Finley.
So want to come back Friday?
Yes, please.
I already have in place an order that she can be released whenever her holder's lifted. So
Yes, sir.
she can go to treatment then, and then common pleas agrees. You might be in treatment by next Friday. That's December.
All right, thank you.
December 16th. Be the next hearing for pretrial.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Hobart Gearhart, case number CRB 22764, CRA 22752, TRC 222479, A and B, CRB 21815, A and B, CRB 21781, CRB 22477, CRB 22383, and CRB 22342.
Hobart Gearhart is Mr. Morford's case, and
Appears in front of Common Pleas Court, Your Honor.
Mr. Gearhart, do you know when your hearing is in common pleas?
It's my knowledge, sir, it's the 21st, but I believe it's hopefully on the bill, so there's no reason to get hell. I'll keep on there. I've done everything I'm supposed to do.
You think they're holding you on what?
Because of this weapons charge.
Weapons under disability.
Oh, that's the one in, is that the one in common pleas?
No, we have it here, Your Honor.
I gave you an OR bond.
I know, sir, but I believe they're holding me because of
Probation violation. It's a probation or parole violation under weapons under disability.
Okay, so common pleas has a holder for.
because of this judge.
All right, so, and you don't think you go before the common pleas judge till December 21st?
That's the best of my knowledge, sir. I'm not 100% sure, but that's what my girlfriend told me.
Judge.
December 23rd then? For the next hearing here?
I'm sorry.
Your Honor, I wanted to do two things, if I may. One of them is I'll send a text message to Carl Bowen and see if this is the one and only thing that has caused him to be violated. If it is, then maybe we can address that matter and see what the probation department wants from him, if we have time for me to do that. The other thing is, I'm concerned about the daggone cows.
That's what I was gonna ask you
Are they
about.
out running the road now? See, we got a new one of those charges on him too.
I know, yeah. Who's taking care of your cattle, Mr. Gearhart?
My girlfriend's trying to do the best she can, Your Honor. She's really struggling. I mean, every time I talk to her, she's really crying. I mean, I'm going to rock in the hard place here. I just can't catch a break, don't say why.
Well, we'll talk to adult probation and see what they're looking for and see if we can speed things up. So let's recall him after Mr. Heald reaches out to them.
Okay.
So we'll call you back, sir. Put the next person on deck in your hot seat.
State of Ohio versus Caleb McDonald and Stephanie Romans is on deck. Caleb McDonald and Stephanie Romans is on deck.
Her case number is 21229. There is Miss McDonald. All right, Miss McDonald, can you hear me okay?
Yes, sir.
Okay, so the allegation is that you had relapsed and were using, and that was discovered in your treatment program, so you were ordered taken back into custody and your bond revoked. You still got a pending felony. So you're...
I'm sorry.
You don't have to say anything, I'm just explaining why you're in jail. So your attorney is Mr. Coates, and he is not here today, so I can set another hearing when he can be here. But that's why you got placed in custody.
Okay, can I say something?
Well, you might want to wait till your attorney is present.
Okay, there's no way I can get an OR, is there?
No.
Or a bond?
Where have you been living?
With my mother. She's been sick. I took her to the doctors, and like nobody can figure out what's wrong with her.
So I take it from this you're denying that you relapsed?
Yes. I even passed the drug test.
Okay, well, we're going to need to get, were you at Mahajan? Is that where you were?
No, land of Goshen.
Land of Goshen, okay.
Yes.
Well, they need to submit a report to the court.
I'll reach out to Allison.
Yeah, see if we can't get a report. As of now, I'm going to revoking your bond and making it, you did have an OR bond, and then I'm going to revert it back to cash or surety. So 10,000 cash or surety, and I'll put you on the docket for Monday, which is the 12th.
Okay.
And I'll let Mr. Holt know, and then if something comes in and convinces me that this is specious, then I will change it to an OR bond.
Okay, but so you said as of right now, I do got one.
As of right now, you got a $10,000 cash or surety bond.
Okay. Now, can you help me understand this? $10,000, does that mean $1,000 can get me out?
Yes. To a bail bondsman, if they'll...
Your Honor, in the computer, it says a bond motion. Is that correct? In other words, someone on the bond or that one off the bond, or is that just an error on the part of
It's a bond revocation.
Okay, I think it was put in as a bond forfeiture, that was just an error.
He probably didn't once off the bond, maybe. Did you have a bond up with Mr. Sowards?
No.
I didn't think so. I thought she had a, well, it is bond in the sense that she had an OR bond.
Well, I think the deputy clerk just misunderstood and put it as a bond forfeiture hearing rather than a bond revocation.
Okay, I'll continue as a bond revocation for Monday since your attorney can't be here today.
Allison from Land Negotiations on the phone. Do you want to speak to her on speaker or here?
Yeah, let's bring it up and handle it right now. Okay, I've got somebody from Land Ocean on the speakerphone.
She's not delivered to Majors in his house.
Okay.
Go ahead.
Can you, ma'am, explain what happened with Kayla McDonald at your facility?
Yeah, I can. So Kayla was originally inpatient in our facility, and she went and moved into outpatient, and then would come to group. She did that consistently for a week, and then she told us she was sick, so she called in, or needed to call in for telehealth. And then after that, she claims that she was in Tennessee for 3 weeks, and just couldn't come in. So we, told her that she had to be at our facility. And she said, I can't come in because I can't be back till Monday. Well, she was only in Tennessee for one of those weeks. She was just evading coming in, so she was tested. And her mom confirmed that, and Kayla confirmed that as well. Kayla admitted to snorting Seroquel and to using heroin. But this was only after like a 2-hour conversation with her and like 6 of our clinical staff confronting her, and she adamantly lied. We discussed like the level of like how much of a pathological liar she really is. And I don't think honestly at this time that she is suitable for any kind of unit that can really address her needs, but she is more of a star case.
Okay, well, thank you for the report. I've scheduled her for Monday, so. All right, could you hear that, Ms. McDonald?
Yes, sir.
Okay, so I'm scheduling you back on the docket for Monday. I'll let Mr. Holt know that you're on the docket for then. Hopefully he can be here, and we'll take it up then and decide how we're gonna proceed.
Okay, but I do have a bond?
10,000.
Okay, thank you, sir.
State of Ohio versus Stephanie Romans, case number TRD 173010, TRC 171080, and Gregory Webb is on deck.
Stephanie Romans.
Yes.
And it looks like, ma'am, you failed to appear for a review hearing on October 14th. And then you got arrested here just recently on the warrant for missing your hearing. Is that right?
Yes.
Do you admit
Yes, sir.
Do you admit or deny you failed to come to court when you were ordered to?
I admit.
You got a good reason for not coming?
Actually, I have a caseworker that actually writes all those dates down, and we did not have that date.
Okay. Where are you living now? Still in South Point?
Yes.
How long have you been in jail?
Since Tuesday.
Oh, okay. Most of the week. Will you come to court if I let you out now, the next time I give you a date?
Yes, sir, would you please?
I think I will. Okay, I'm going to give you a new date. Let's make it the first Friday in January, so that should be easy to remember, right? First Friday in
Yes,
January.
sir.
January 6th.
Yes.
January 6th.
January. Okay.
And they got to be here at 9 a.m.
All right, thank you.
So I'm fine you in contempt, sentence you to 4 days in jail, credit for time served. Come to court January 6th. You still got stuff you have to complete. You got some community service and fines to pay.
Yes, sir.
Okay. January 6th is going to be your next hearing, 9 a.m.
Okay. All right.
State of Ohio versus Gregory S. Webb, case number CRA 05775, A and B, and Jamie Welch is on deck.
Gregory Webb. All right, Mr. Webb is here. You were in Scioto County, right?
Yes.
And now, is this the only thing you've got in our county? You got other stuff?
Yes.
Looks like you missed a hearing back in November of 2018. So 4 years ago. And you have still owe fines and costs, and maybe it's restitution, I don't know. Where are you living now? If you get out of jail, where will you be living?
In Huntsville, Virginia.
Okay.
I've recently lived in rural county the last 2 years, and I was sending money because of the quarantine and stuff. And then I got homeless about a year ago, then I was quarantined about March of last year. Then I was quarantined for like 3 months till I get my own place. And
So you got a place to go to in Huntington?
yes, sir.
Who's that with?
My mother.
Your mother?
Yes.
How long do you, well, you were in jail for quite a while in Scioto County, weren't you? Because I see you wrote me back in the beginning of November from the jail down there.
Right, I lived for almost 65 days. They unlocked me the day I showed up here, so I had a hold on me for that long period.
Okay, I'm going to set your next hearing. I'll send you the time, sir, for not coming to court. January 6th will be your next hearing. First Friday in January, 9 a.m.
What time?
9 a.m., January 6th, first Friday in January. Come to court, or pay off your fines.
Hey, am I being released?
I'm sorry?
Sorry, George, am I being released?
Well, I'm going to release you. I don't know if there's any other court that has a holder on you, but I'm releasing you.
I appreciate you, man.
Okay, you're welcome.
State of Ohio versus Jamie Welch, case number CRA 22774, CRB 21357, TRC 183432, TRC 141184. And Kerry Wheeler is on deck.
This is like top 7. Now we're at 70. I remember when we were top 50. I think we've reached the top 75, right? Have we been in business 75 years? Has it been that long? The NBA had us top 50 the first 50 years. I think they're doing the top 75 the 75, first 75 years now. It's kind of like that today.
Is it almost time for another induction ceremony?
Yeah. All right, Jamie Welch. And you looks like you got a new charge, Miss Welch. Oh, it's out of state. You got a holder from Kentucky.
Yeah, I signed that condition off this once before, and they never came and got me.
Okay, well, apparently they never withdrew your warrant. It's libel and slander, resistance to something. They don't want you to post a bond. Well, it's a Jamie L. Welch of 7096 County Road 158. Date of birth? December 24th of 83. Is that your birthday?
Yep.
Christmas Eve. Wow, that's a bad time to be born. You don't give me
Yeah.
Especially if you're in
your birthday present.
If you're in a manger or something too, that could be a...
Well, oh, they say this is a burglary charge in addition to what?
Yeah.
Okay, so they want you on a burglary charge in Kentucky. And then you had here, in my court, it's alleged you didn't come to court in May 2nd for a review hearing on several charges. You have warrants on all that too.
Yeah.
So do you want a lawyer? Do you want to fight going to Kentucky? Do you want to agree to go to Kentucky?
I mean, I guess I'm gonna sign extradition and do what I gotta do, because it's not going in if I don't.
True. I'd say that's right.
Yeah.
So you want to agree to go to Kentucky?
I guess so.
All right, well, we'll send down the waiver. I'll set bond. I think they don't want a bond, but I'm going to set it at $25,000. I'm assuming that's not a bond you can post. Right? 25,000?
Probably not. Nope.
So I'm ordering them to come get you by next Friday, which is
All right.
the 16th. So the jailers listening in, you need to let Kentucky know they can pick her up anytime. But they need to do it before December 16th at 8 a.m.
Okay.
Then I'm putting
Thank you.
You're welcome. And I'll withdraw, on my cases, I'm going to withdraw the warrant so you can go to Kentucky, and I'll give you a review hearing on February 3rd.
Okay, thank you.
That's the first Friday in February.
Okay.
You said February 3rd, Your Honor?
Yes. I'm about worn out, Mr. James. How many more files you got to do?
We're almost done, Your Honor.
Okay.
Hallelujah.
State of Ohio versus Kerry Wheeler, case number CRB 22776 and CRA 22765, A and B. And Hobart Gearhart is on deck.
I signed your entry on time, so you want to take it?
Thank you, Judge.
You get it. Time stamp. All right, Kerry Wheeler has a new charge, unfortunately. And Miss Wheeler, you know who I am,
Yes, sir.
and you could probably recite your rights back to me as well as I can recite them to you, but I guess I need to do it. You have a right to remain silent. If you say anything, it can be used against you. You have a right to have an attorney appointed if you can't afford one, to have bond, make the state prove these charges beyond a reasonable doubt. You understand all that?
Yes, sir.
Okay,
Yes.
you got a new charge of violating protection order. It alleges that on December the 6th, in Rome Township, you recklessly violated a protection order. That's a first-degree misdemeanor, maximum penalty is 6 months in jail, $1,000 fine. And then I'm also told that you left treatment in violation of your bond on 22765 case and walked from OVP in Burlington to Rome Township, where it's alleged you violated protection order. So, do you understand the charge?
Yes, sir.
Your attorney's here, Mr. Morford, on the other case, so I'll appoint him to represent you on this one.
Okay.
And what to do. That's a healthy walk. That's probably 11 miles, I'm gonna guess, you walked?
I didn't walk 11 miles. Someone gave me a ride.
Okay, well, you proved that's what I always, these people tell me all the time, I can't get to court, they live like 3 miles down the road. Judge, I can't get there, I can't possibly get there, I don't have a car, I'm 3 miles away. Well, you just proved, when you want to get someplace, you can get someplace. When you don't want to get someplace, you won't get there.
Yes, sir.
Judge, I had a note from when we were here last that she was being looked at by OVP. Carrie
Who was that OVP?
Oh, okay.
She got picked up by OVP and left OVP to go.
I'm behind.
Isn't that correct? Well, you don't have to say, you don't need to say anything. That's my understanding. She was at OVP and left.
Got you.
Now, the tall tale is that she walked from OVP all the way to Rome Township, but she's must have thumbed or got a ride or something, she says. So, I'll enter a not guilty plea on this new charge. What's the state's position on bond?
Well, Your Honor, given the current circumstances and the history of this case, we believe that a cash or surety bond of $2,500 is appropriate. And as far as what should happen ongoing, we really haven't been able to make up our mind yet because there's so many factors to try to consider.
Well, and you're asking whether there already was a TPO. Do you want a double TPO?
I don't know if a double helps or not, but according to this report, she even told the officer, I know I've got a protection order. So
we'll make it a double. So you're double ordered to stay away from Daniel.
Yes, sir.
Do you understand, Carrie, that if you don't stop violating the CPO, that Mr. Hield's going to be asking for probably the maximum amount of time he can put you behind bars?
It's not gonna happen. I mean, I can assure you 100%. I mean, as much as anybody would believe me right now, but I've never violated anything before. I'm not gonna do anything. I just want to get this. I just want to do the right thing. My animal died while I was in jail, and I left treatment and I went home. I don't know what else to say.
Well, they take violating a court order very seriously, and I can tell you Judge Capper doesn't issue them without expecting them to be ordered, or followed, excuse me.
Yes, sir.
Okay, so when are we going to come back? Maybe in a week?
Please, Judge.
Okay. Next hearing is going to be on the 16th, December 16th, for pretrial.
I stay jail until then.
Well, you can post bond, $2,500 cash or surety. Do you want to talk to Mr. Sowards?
Yes, please.
Okay, we'll let him know.
I'll let him know.
State of Ohio recall Hobart Gearhart, case number CRB 22764, CRA 22752, and on and on.
Did we find out anything about Mr. Gearhart?
Yes, sir.
Your Honor, I spoke with Chief Bowen from the Bureau of Community Corrections at the Common Police Court. He indicates that they've got other reasons to want to hold him for a community control violation. So I don't know what date he's going to be going to court, but hopefully it'll be pretty soon so that he'll be able to figure out what it is that they want from him. We have this weapons under disability charge, which we'll go ahead and nollie that to the grand jury. I don't know what's going to come of that, but the grand jury can consider whether there should be an additional charge or not. I think his probation that he's already in a pickle with them is probably as big a problem as he has, besides all of the cases that he has here, which he's already been found guilty of.
Okay, so that's 22,752 nollie to the grand jury?
Yes.
Everything else will stay here, and when do we want to come back on those?
Everything is, there's one more animals running at large charge that's pending, and then there are several that have been, we had a trial on, so they're here for sentencing. And honestly, from my perspective, I'm worried about those daggone cows. I believe, and we presented a case to the court, Your Honor, which you should have in your file, which authorizes the court to order the forfeiture of those animals. I don't want him to lose those cows, but I bet they're out there running around now.
Yeah, and how, I mean, what's the mechanism?
I
Order
don't
the
know.
sheriff to, who's gonna want to take possession of the cattle?
No idea. I wish that he had a neighbor who would say, I'll take them and care for them, but I don't know if he does or not. They've been, running all over their property.
Yeah.
She has dispersed of, I believe, 6. I believe she got rid of 6.
How many did you have?
18. I don't know that I might be able to get rid of a few more maybe this coming week. I don't know if that's possible or not, but if I can get somebody to help her all along. I was not aware. I mean, I've done everything for me. I don't know what they want from me. I don't know what I'm supposed to do. I never felt those things. I don't know what's going on there, but I was under the impression that Roman was because of the gun charge, which, I mean, really, I didn't do anything there either.
Well, we're dismissing that to the grand jury, so it's not even here pending anymore. It'll go to the grand jury, they might indict you on it, but, so what your problem right now is Common Police Court has a holder on you for some sort of probation violation, is that right?
Judge, I don't understand what that is. I mean, I don't understand what it would be.
I looked, and he does not have a court date yet on the probation violation.
They told me my girlfriend told me they told her the 21st. Now, whether that's correct or not, I'm not sure.
It may not have made it to the clerk's website yet.
Well, that's a Wednesday, so that makes sense.
I haven't, I mean, I didn't have any kind of warrant on me. They didn't have any kind of warrant on me. I mean, Lord God, I've been in front of, I don't know how many police officers. I mean, I go to meter reads every time I'm supposed to, and I go take my drug test when I'm supposed to. I don't understand what they could possibly have on.
I think in part, Judge, the probation violation alleges that he has not reported in over a year.
That's what Carl Bowen says.
Okay.
And so I don't know to what extent.
That's an allegation, I don't.
I'm sorry. He also said that there was a hearing in Common Pleas on the 14th, so that may
Well, that's even better.
Well, you want to come back next Friday just to check and see?
Yes.
Okay, I'm going to schedule you for December 16th, 1 week from today, in my court. If you get out of jail, you got to come to my court on next Friday. Obviously, if you're still in jail, I'll see you on teleconference.
And we have, I believe, an OPI in addition to the animals at large, Judge.
They're still pending, right?
Yes, sir.
For sentencing.
Yes.
For sentencing.
I thought we played after that to the physical control.
It's been played to, Scott, but we have not had a sentencing.
But we did the physical control. He wasn't in the vehicle at the time
Okay.
that the patrol arrived.
Okay, next Friday is your hearing here.
10 o'clock?
10 o'clock, yes,
10
sir.
o'clock?
Yes,
Thank you,
sir.
Your Honor.
Okay. That
Butch,
does
I
it.
definitely need to see you. Butch Wolford, I really need to see you.
I'll call you.
Thank you.
Court's adjourned.
So one of these is Jackie. I got this.
Mr. Elkins and Mr. Green.
Judge, can I get you signed?
Sure.
I've got a mess.
Yeah.
On the pending animal running at large case.
That goes to.
Oh, I know.
Was that knowledge in there?
Sure.
Yes.
Oh, yeah.
Okay.
We got a pending animals running a large case that needs a time waiver.
How are you doing?
Needs a time waiver. Oh, God.
Yeah.
Uh-huh.
Wait,
That's got,
okay, this one's not to the grand jury.
yeah. So here, I need to
Just
do
bring a lot of
time
things
waiver.
himself, but I think sometimes
I guess they're all over
it's
there.
the worst possible outcome.
Oh, I just put them up.